17th Congress was one of the most well-accepted and trusted Senate by the people. So hopefully in the 18th Congress we'll be able to do better. We expect more healthy debates, and we expect that there will be better legislation or necessary legislation that will be passed. Welcome to the 18th Congress.
President and the Senators of the Republic of the Philippines.
The fourth session of the Senate in the first regular session of the 18th Congress is hereby called to order. Senator Ronald De La Rosa will lead the chamber in prayer.
Let us bow our heads and put ourselves in the presence of the Lord. Almighty and eternal God, we thank you for this opportunity to serve our beloved nation as members of this august chamber. Bless us, your public servants, especially the new members of this chamber, and fill us with your wisdom, understanding, patience, and discernment as we commence our work today and in the days to come. Enter our hearts and minds and use us as your instruments of peace, love, and understanding. Enlighten and strengthen us as we face the challenges of our work and help us pursue only what is for the common good in accordance with your will. Lord, we offer this day and all the days of our service for your greater glory. In Jesus' name, amen.
Amen. The Senate choir will lead us in the singing of the Philippine National Anthem. Secretary, will please call the roll.
Roll call of members, the Honorable Senators Angara, Binay, Cayetano, De Lima, De La Rosa, Drilon, Gatchalian, Go, Gordon, Ontiveros, Lacson, Lapid, Marcos, Pacquiao, Pangilinan, Pimentel, Po, Recto, Revilla, Tolentino, Villanueva, Villar, Zubiri, Senate President Soto III.
With 20 senators present, the chair declares the presence of a quorum. Majority Leader.
Mr. President, may we recognize Senator Pia Cayetano?
Senator Pia Cayetano is recognized.
Thank you, Mr. President. Just a manifestation, Mr. President. In 2012, I brought to the attention of the body that we should do our part in saving our environment and not use plastic PET bottles, at least in the session hall and in our hearings. And this was adopted, I think also in the lounge, and this was adopted for, at that time, 2012 onwards, but I don't really know what happened in the 17th Congress because I wasn't here. So may I propose that we adopt that once again, especially since it is July, which is No Plastic Month. And to help support my colleagues in shifting to a more sustainable way of drinking water or whatever beverage you prefer, I am giving all of you a thermos. On behalf of Tita Cynthia's birthday and advocacy, it is made from bamboo. So that is my simple manifestation, Mr. President.
Senator Pangilinan is recognized.
Thank you, Mr. President. I'd like to thank Senator Pia Cayetano for that manifestation. This representation filed a bill on single-use plastics, and we join her in her advocacy, Mr. President, for the record.
All right.
Yes, Mr.
Place
President.
that on record.
We'd like to also reiterate, it is the birthday today of our distinguished Senator, Mama Bear, Cynthia Villar. She is now 51 years old.
I thought 50.
50 pala, nagkamali po ako. Our principal.
Happy birthday to our principal. May we suspend the session for a minute.
To greet her. Thank you, Mr. President.
Malamig ha? Hindi malamig yan. Hindi malamig. Session is resumed.
Thank you, Mr. President.
Mr. Majority Leader.
And Mr. President, before all of us forget, it was also the birthday of Senator Sani Angara last July 15. So these two distinguished members of the Senate owe us a blowout, Mr. President.
The statute of limitations
Wala.
for blowout is finished.
No such thing. No such thing. So, Mr. President,
We greet Senator Sani Angara a very happy birthday.
happy
likewise.
birthday as well to the good chairperson of the Committee on Finance. Mr. President, before we take up important matters, we just have in the session hall friends from Mabini, Batangas. Mayor Noel Luistro is here together with his Vice Mayor June Villanueva and other councilors of Mabini, Batangas. We have also with us Mayor Hajiri of Lugus Sulu and Vice Mayor Medj Hajiri of Lugus Sulu is here with us as well. All the way from Lugus Sulu, which is, I'd say, 30-minute ride to Malaysia already, or Sabah.
All right.
And we have also members of the Alt Mobility Philippines, headed by Ira Cruz, and Jen Ugay, and several others also here with us in the Senate.
We'd like to welcome our guests to the Senate. Mr.
President, before we
Majority
take up-
Leader would like to entertain a motion to discuss the journal.
Yes, Mr. President. Mr. President, I move to dispense with the reading of the Journal of the third session, Wednesday, July 24, 2019, consider the same as approved. I so move.
Any objection? Hearing none. Motion is approved. Journal is approved.
Thank you, Mr. President. Before we tackle the reference of business, there are three of our colleagues who want to deliver privileged speeches, Mr. President. If with the permission of the body, we take these privileged speeches up. I move to recognize, Mr. President, Senator Francis Tolentino to deliver his speech. So moved, Mr. President.
Senator Francis Tolentino is recognized.
Mr. President, I rise today humbled to offer the first privileged speech for the 18th Congress as a senator from Cavite and the province of Albay. I rise with a deep sense of respect for this institution and to the incumbent Senate leadership. I rise on behalf of the Filipino fishermen who are struggling to make a living. Mr. President, honorable ladies and gentlemen of the Senate, I rise to speak on matters of national significance concerning the West Philippine Sea. This humble representation will try to establish three important points this afternoon. First, that President Rodrigo Roa Duterte has the power to enter into legally binding international verbal agreements. Number two, there is a need to protect the rights and safety of Filipino fishermen and secure for them the benefits of peaceful utilization of available marine resources. Number three, that it is crucial for this august body to craft legislation to uphold constitutionally and internationally accorded rights over the waters of the country, and at the same time to ensure that international commitments are honored and complied with. Proceeding with the first point, Mr. President, President Duterte can validly enter into legally binding international verbal agreements with other states for in behalf of the Philippines. Under international law, states must honor the commitments it takes upon itself under international agreements and treaties, regardless of the form used for its execution, which may be written, oral, or even implied. There is no restriction on either the form or substance of international agreements. The domain of permissible international agreements is simply the domain of possible agreements. In the case of passage through the Great Belt, which is the case of Finland versus Denmark, a 1991 case, the International Court of Justice concerning Denmark's construction of a bridge in the Great Belt a strait between the Danish islands of Zealand and Funen, to which Finland argued to violate its right of free passage, the ICJ dismissed the case on account of an oral agreement between the Prime Ministers of Denmark and Finland resolving the conflict on their own. The negotiation and eventual oral agreement between the two leaders transpired over a mere telephone call. The International Court of Justice honored this agreement and dismissed the case. In another case in 1993, involving the legal status of Eastern Greenland, Denmark versus Norway, filed by Denmark against Norway, the International Court of Justice considered as binding the statements made on July 22, 1919 by Norway's Foreign Minister, Mr. Ilhem, in reply to Denmark's official query. Ilhem stated that Norway would respect the Danish sovereignty over Greenland. The court declared this statement as binding on the part of Norway, considering that a reply of this nature given by the Minister of Foreign Affairs on behalf of his government is in response to a request by the diplomatic representative of a foreign state. Informal agreements, such as oral agreements, are valid under international law because under certain situations, they are the most effective tools to reaching an accord between states. Informal international agreements are used to meet particular needs. They are chosen to allow governments to act quickly and quietly. States sometimes frame their agreements in informal terms to permit their frequent adjustment. For example, in the quota arrangements of the Organization of Petroleum Exporting Countries, or OPEC, the informal agreements permit rapid shifts in the response to rapidly changing market conditions relative to the supply of crude oil. Lastly, when security issues must be resolved quickly or quietly to avoid serious conflict, the less formal instruments will be chosen. If the terms are especially sensitive, perhaps because they would humiliate, embarrass one party, or convey unacceptable precedents, then the agreement itself may be hidden from view. For example, the deal to remove the missiles from Cuba during the Cuban Missile Crisis, the most dangerous crisis of the nuclear era, was crafted through an exchange of letters supplemented by oral promises initiated by then President John F. Kennedy to his emissary, then Attorney General Robert Kennedy, in dealing with Prime Minister Khrushchev. The Cuban Missile Crisis ended without firing a single shot. Hence, oral arguments are binding as long as it is clear from the language employed that there is an intention to be bound. In the Philippines, Mr. President, news agencies have reported through several articles that President Duterte had entered into an oral agreement with China during His Excellency's bilateral conference with President Xi Jinping in 2016. If indeed this was the case, President Duterte was well within his powers to do so. As chief architect of the nation's foreign policy, the President can enter into executive agreements with other nations for the execution and implementation of the laws crafted by Congress, as well as treaties entered into by our country. These executive agreements, with due respect, do not require Senate concurrence. As explained in the landmark case of Sagisag versus Ochoa, decided January 12, 2016, the case that ruled that the Enhanced Defense Cooperation Agreement with the United States is a mere executive agreement if an international agreement is traceable to an express or implied authorization under the Constitution, statutes, or if they involve the implementation of existing policies, laws, or agreements, or if they are just concluded to adjust details of a treaty pursuant to an act of the legislature, or if it is simply in the exercise of the President's independent powers under the Constitution, then the agreement is a mere executive agreement that does not require the Senate's concurrence. In the previously mentioned case, even Justice Antonio Carpio wrote in his separate concurring opinion that the implementation of the Mutual Defense Treaty is a purely executive function since the Senate has already ratified it. And as the chief architect of the country's relations with foreign countries, the President is constitutionally vested with ample discretion in the implementation of the MDT, or the Mutual Defense Treaty. In other words, Mr. President, this humble representation submits that there is no need for this honorable body to concur to the alleged oral agreement between President Duterte and President Xi Jinping, because it is merely in implementation of the provisions of UNCLOS, and secondly, an implementation of other treaties such as the Straddling Fish Tax and Highly Migratory Tax Agreement, the Food and Agricultural Organization Code of Responsible Fisheries, among others, which I will expound later on. Mutual respect for the three branches of government must be maintained by avoiding interference or deciding on matters involving political questions which fall within the exclusive authority and competence of the President. The conduct of foreign relations is full of complexities and consequences, sometimes with life and death significance to the nation, especially in times of war. It can only be entrusted to the Department of Government, which can act on the basis of the best available information and can act swiftly. It should be entrusted to someone who possesses the most comprehensive and the most confidential information about foreign countries and who has also unlimited access to ultra-sensitive military intelligence data. In our case, the President of the Republic of the Philippines. Mr. President, I rise likewise on behalf of our Filipino fishermen who are struggling to make a living in the West Philippine Sea. Proceeding to my second point, there is a need to protect the rights and safety of Filipino fishermen and secure for them the benefits of peaceful utilization of available marine resources. It is a fact that a significant number of Filipinos rely on our seas as a source of livelihood. In order to protect the marine resources vital to this industry, the country has entered into various international agreements, all aimed at the conservation of our seas and the management and utilization of its resources. One of these agreements is the United Nations Convention on the Law of the Sea, on UNCLOS. This convention has granted the country numerous rights for the attainment of economic stability as well as obligations for environmental conservation and international peace. Among these obligations is the mandate to cooperate with other states in the protection and utilization of our exclusive economic zone, or the EEZ. Historically, Mr. President, the EEZ, formerly known as the exclusive fishing zone, is defined as an area beyond and adjacent to the territorial sea which shall not extend beyond 200 nautical miles from the baselines. This was first introduced by the Western states in the 1940s. In 1947, Peru and Chile unilaterally proclaimed a 200 nautical miles EEZ, while in 1952, Peru and Chile entered into a treaty called the 1952 Sancho Declaration with the objective and purpose of a coordinated conservation and protection of the natural resources in the parties' extended maritime zone. On the other hand, following what has already developed into customary international law, the Philippines declared its own EEZ to Presidential Decree 1599 in the year 1978. The 1987 Constitution also contains a provision on EEZ as part of the section on national patrimony and economy, as it provides in Article 12, Section 2, Paragraph 2 thereof. And I quote, that the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. The term EEZ in our Constitution was adopted from the UNCLOS itself. This can be readily seen from the very deliberations that proclaim the provisions and the fact that it was inexistent in the 1935 and the 1973 constitutions. The UNCLOS, the convention that granted us sovereign rights, not sovereignty over the sea, provides for and promotes the spirit of cooperation among states, from the provisions of sharing the surplus of allowable catch in the EEZ to managing straddling fish stocks and highly migratory species, and to sharing with landlocked and geographically disadvantaged states under Articles 69 and 70, the UNCLOS urges, nay compels the states to cooperate with each other for the preservation and utilization of our oceans and seas. The spirit of the Convention has been befittingly espoused by the Constitution, our Constitution, that adopted its terms. Looking into the minds of the commissioners that crafted the Philippine Constitution, it is indisputable from the records on August 25, 1986, that as proposed by former Chief Justice Roberto Concepcion and as adopted by the committee, it was intended that the word exclusive economic zone in the cited provision would refer only to the exploitation of the seabed and the waters above that portion form part of the high seas and are subject to the general principles of international law. General principles of international law, as referred to by the former Chief Justice Concepcion, are universally accepted principles fundamental to all legal systems and recognized by civilized nations, one of which is Pacta Nun Servanta, which dictates that international agreements which are legally binding must be performed in good faith. Following this principle, the country is mandated to ensure that it honors its commitments in the international arena concerning treaties that it has validly entered into regardless of form. Justice Isagani Cruz, in his book on international law, says that the country must always strive to perform its obligation in good faith, despite the hardships such as conflicts with the Constitution, domestic law, or national interest. This principle is emphasized in the Vienna Convention on the Law of Treaties, and I quote Articles 26 and 27 thereof, which provides, every treaty in force is binding upon the parties to it and must be performed by them in good faith, and that a party may not invoke the provisions of its internal law as a justification for its failure to perform a treaty, unquote. An international arbitration case, Mr. President, to cite one, worth noting, is the Alabama Claims Arbitration case decided in 1872, wherein the British were ordered to pay the United States for breaching their agreement of neutrality by failing to stop the construction of warships in their country that were used in the U.S. war. The arbitrator in that case rejected United Kingdom's excuse that they only breached the treaty because of the insufficiency of legal means available to them under their domestic law. The Philippines then must honor its commitments to the international community, especially concerning cooperation between states in the conservation and protection of our marine resources. In the words of former Chief Justice Artemio Panganiban, in the case of Tañada versus Angara, May 2, 1997, I quote, "The Constitution did not envision a hermit-type isolation of the country from the rest of the world. The Constitution did not intend to pursue an isolationist policy," unquote. Russia and Norway, through the Barents Sea fisheries regime have decided to grant mutual access to their respective EECs in the light of their shared fish stocks and fishing grounds. Through their collaboration, both countries have established an effective fisheries management system without jeopardizing the competing claims of sovereignty over the sea. Their bilateral agreement has facilitated in scientific research and has improved compliance control over the area to prevent illegal, unregulated, and unauthorized fishing. In the Pacific, Mr. President, countries such as the Federated States of Micronesia with Kiribati, the Marshall Islands, Papua New Guinea. Papua New Guinea is a classic example, having granted 29 fishing rights to Filipino fishing companies. Solomon Islands, among other states, have all realized the need and the benefits of working together. These countries have established a multilateral fisheries management agreement in order to more effectively utilize and manage their shared resources. Other Pacific countries such as Cook Islands, Fiji, Gilbert Islands, Nauru, New Zealand, Tonga, Tuvalu, and Western Samoa all share in the sentiment that the best and only way forward to a more ecological and economically feasible fisheries regime is through international cooperation. The United States of America and Canada in the management of the Pacific salmon, Angola, Namibia, and South Africa in the management of fishery resources in the Benguela large marine ecosystem, and near us, New Zealand and Australia in the management of the South Tasmanian rice and more. The list goes on to include more countries that have made this realization. As a matter of fact, a 2016 study by the World Bank shows that around half of the world's exclusive economic zones are subject to some form of foreign fishing arrangements, be it through access agreements, joint ventures, or even just chartering. The benefits of international cooperation, when properly executed, are limitless. Another case in point is Morocco, who receives access fees from the European Union countries to fish within its EEZ. Study shows that 75% of the socio-economic impact of their agreement is for the benefit of Moroccans. Another international commitment the country must honor, with due respect, Mr. President, is the Food and Agriculture Organization, or FAO. On October 16, 1945, the Philippines joined the Food and Agricultural Organization, a specialized agency of the United Nations that leads, among other members of the international community, with the goal of achieving food security by creating and sharing critical information about food, agriculture, and natural resources, and by transporting the transition to sustainable agriculture. Towards this end, the regional fisheries bodies around the world was created, and one of which, a neglected organization called Asia Pacific Fishery Commission, that was organized in 1949 in Baguio City, Northern Luzon. The Asia Pacific Fishery Commission is an advisory body and coordinating mechanism composed of several states, including China, Australia, Bangladesh, the Philippines, France, India, Indonesia, New Zealand, among others. They work together, they should work together, they were envisioned to work together towards the conservation and management of fisheries to promote a fully sustainable utilization of aquatic resources through policies and practices, including finding solutions to regional issues that affect the member states. However, the disputes in the West Philippine Sea caused by overlapping claims of exclusive economic zones have been a continuing hindrance to achieving the aims of the Commission. As a result, no institution concerning fisheries has been established to monitor and manage the resources of the West Philippine Sea. The states fishing in the area, including the Philippines, continuously fails or does not accurately report its catch to the FAO or the APFIC, while BIFAR, or the Bureau of Fisheries, and Aquatic Resources of the Department of Agriculture has set a catch ceiling limitation for tuna. The Philippines has not set allowable catch ceilings and has no data regarding the optimal catch in its EEZ. The last data reported, as per my research, was 2012. The failure to set these standards and to report information regarding the resources in the West Philippine Sea is detrimental to the conservation and management of the area. The conservation of the reefs in the West Philippine Sea is critical to the supply of marine resources, not just to the Philippines, but to the whole world. In order to achieve this goal of conservation, management, and full sustainability, cooperation and coordination with our ASEAN neighbors is imperative. As a signatory to international agreements, including the 1995 Agreement for the implementation of the provision of UNCLOS relating to the conservation and management of struggling fish and highly migratory fish stocks, which the country ratified on September 24, 2014, the Philippines is bound to pursue cooperation through bilateral, sub-regional, and regional fisheries arrangements to avoid overfishing, promote responsible fishing, conserve the biodiversity of aquatic habitats and ecosystems, and protect endangered species and restore depleted stocks. Though running late, the Philippines has made the initial steps for this endeavor. Last June 3, 2019, this August Chamber has given its concurrence to the Philippines-Indonesia EEZ delimitation agreement that the country has ratified on February 15, 2017. This is a major step, as the resolution of this dispute through peaceful means will be the start of a possible future joint cooperative endeavors with Indonesia in managing our very close and adjacent waters. As we strengthen ties with other Asian nations who share in the abundant resources of the West Philippine Sea, we take advantage of cooperation through access to scientific, eco-marine data, as well as the protection of our resources from illegal, unregulated, and unauthorized fishing. The journey towards sustainable development is still long and winding. The seas to be traversed are rough, but what is important is that the country keeps on sailing. Having emphasized, Mr. President, the need to honor our commitments to the international community, it behoves upon us, distinguished members of the Senate, to rise up to the challenge of navigating through the uncharted realm of international law in order to protect our resources and uphold the rights of every Filipino. While cooperation with the international community is important, the welfare and benefit of the Filipino people should always be a priority. Of all the country's resources, it is the people that is most treasured, protected, and must be served. Hence, Mr. President, may the 18th Congress endeavor to enact more meaningful legislation to fortify, defend, and uphold the rights and satisfy our obligations for the benefit of our countrymen as well as our dignity. Taking cue from other nations that have found it essential to protect their resources and uphold their people's rights, may the 18th Congress enact similar legislation, such as the United States Outer Continental Shelf Lands Act, among others, wherein the United States has declared that their constitution, civil and political laws, as well as criminal and federal regulatory laws, are extended and applicable to their subsoil, seabed, and all artificial islands and all other installations attached thereon. The protection and safety of our people require our foresight in drafting laws as we tread towards further utilization of both living and non-living resources in our sea. This humble representation, Mr. President, calls on this Chamber's support in the passage of these representations proposed Senate Bill 209, the Good Samaritan at Sea Law, that aims to implement the provisions of the International Convention for the Safety of Life at Sea. With this law, Filipino fishermen will be afforded additional safety as they pursue their way of life. This representation has likewise filed proposed Senate Resolution number 12, or the resolution in support of the prohibition of fisheries subsidies in the World Trade Organization, to lessen the perceived disadvantage of Filipino fishermen against foreign entities and to protect the resources in the EEZ against illegal, unreported, unregulated, or IUU fishing, overcapacity, and overfishing. Fishing subsidies that contribute to these problems must be eradicated internationally. The United Nations Conference on Trade and Sustainable Development Goal target 14.6 targets that by 2020, the United Nations member states should prohibit certain forms of fisheries subsidies that contribute to the aforementioned problems and refrain from introducing new subsidies by 2020. The realization of this goal would level the playing field for the Filipino fishermen, as they will be able to perform at the same level as their foreign counterparts. Resources will be more equitably exploited and protected from overutilization while enhancing the lives of the Filipinos. The need to stay true to our international commitments is not just to maintain our international standing, Mr. President, but most importantly, in order to uphold the rights and dignity of our people and protect the nation's honor. This humble representation wishes to end this speech with the words of God Andres Bonifacio in his work, Ang Dapat Mabatid na Mga Tagalog, circa 1896. And I quote, "Kaya o mga kababayan, ating idilat ang bulag na kaisipan at kusang igugol sa kagalingan ng ating lakas, sa tunay at lubos na pag-asa na magtatagumpay sa nilalayong kaginhawaan ng ating bayang tinubuan." Thank you, Mr. President. I yield the floor.
The Minority Leader is recognized. Before we recognize Senator Pia Cayetano.
Thank you, Mr. President. Just for the record, will you gentlemen yield the floor to a few questions?
Willingly to the senior and most erudite minority leader, Mr. President.
Thank you very much, Mr. President. Mr. President, first of all, let me spread into the record our commendation for the gentleman from Cavite for raising and placing on record such an important and critical issue that the nation faces not only today, but in the future, both in terms of the welfare of our people and the fate of our nation. And this is the issue which involves the West Philippine Sea and the provisions of the Constitution which explicitly mandates the protection of our national resources. But let me start this period of interpretation with a request for clarification. We heard the gentleman very clearly on the arguments that he raised on the issue of the agreement between the President and President Xi Jinping of China. But our first question, Mr. President, is can the gentleman spread into the record exactly what the verbal agreement is between the two presidents? Because other than the media reports, I don't think anyone has a record of what the agreement was. Will the gentleman be kind enough to spread this into the record, if he knows?
Mr. President, as what I stated in my speech, the basis of my proposition was related to several anecdotal reports that apparently there was a verbal agreement, 2016, I'm not exactly sure of the month, wherein the President allowed Chinese entities to fish within the West Philippine Sea. But I don't exactly, Mr. President, since it's an oral agreement, I don't have any records of the product of that Salaibatic agreement, Mr. President.
So if we do not know exactly the parameters of the oral agreement, how can we say that this is valid under international law, that is valid under our Constitution, when we do not even know the parameters of this agreement? So before we get into a debate, and what exactly are we debating on?
My premise, Mr. President, is that there have been calls, even from an incumbent, a sitting justice of the Supreme Court, that said oral agreement would require the concurrence of the Senate.
That is why, yes, we heard that. That is why we did not pick it up, Mr. President, because we did not know what exactly to ratify or what exactly to revoke, because we do not know the agreement, the parameters of the agreement. So I think it is incumbent upon the gentleman from Cavite, who so wisely and judiciously brought this issue on the floor of the Senate, to first tell us what the President exactly agreed upon, so that we can debate. For one, is it a valid agreement under our Constitution? Number two, can we ratify this? Or should we leave it at that because we do not know exactly how it stands? So I think unless we have on the record exactly what this agreement are, it's difficult to debate. Given the access of the gentleman from Cavite to the President, is it too much to ask for the gentleman to ask the office of the President to inform him, at least him officially, of what the agreement is all about, so that we have something in writing to rely upon in our debates?
Mr. President, may I refer the distinguished gentleman from Iloilo that there was an instance wherein a similar issue was laid before the Senate concerning the availability of an agreement, and a decision coming from the Supreme Court, if I'm not mistaken, Pimentel versus Executive Secretary, the Supreme Court clearly stated that no governmental entity can force the executive, the office of the President, to produce a treaty for ratification. I'm referring during those days to the Treaty of Rome. It was part of the decision of the Supreme Court that the chief executive cannot be compelled to produce the treaty, much more for an oral or verbal, informal agreement, which is not in writing, but the effectivity of which I have laid down in my speech as needed, not just for commerce, but in terms of national security.
With all due respect to the gentleman from Cavite, if our memory serves us right, the issue in the Rome Statute was whether or not the President can be compelled to submit to the Senate for concurrence the Rome Treaty. The first step in a treaty ratification is for the President to ratify. And after ratification, the ratification is referred to the Senate for concurrence. We are not ratifying the treaty. It is the President who ratifies the treaty, and the Senate concurs in the ratification. That is when the treaty becomes effective. In the particular case of the Rome Statute, then the previous President then did not want to ratify the Rome Statute. And therefore, without the ratification of the Rome Statute, there was nothing for the Senate to concur. Now, the Supreme Court correctly said, you cannot compel the President to ratify a particular treaty. That is a prerogative of the President as the chief architect of foreign policy. If and since the President did not ratify, the Senate had nothing to concur in. It is completely different in this case, Mr. President, because there is an asserted agreement, and this agreement is entered by no less than the President himself, albeit verbally. And since it is now on the floor and up for debate, I think the basis of the debate, at the very least, should be a definition of the parameters of this agreement. What is the agreement all about? At least we should know, we will have a basis as to whether or not it is consistent with the Constitution, as to whether or not it can be ratified, and whatever. The Senate, as the partner of foreign policy in our structure of government, the partner of the executive, at least will be able to exercise his judgment. And I congratulate and commend the gentleman from Cavite for asserting that this is within the jurisdiction and the jurisdiction of the Senate in terms, at least, of the examination of the parameters of the power of the President. The gentleman said this is binding. Question, what are we being bound to if we do not know what the agreement is? The gentleman said oral agreements are valid under international law. What is this oral agreement? What is the basis of our judgment that it is valid under international law when in fact we do not know what the agreement is all about? So I think for us to have a judicious debate on this issue, and again, I commend the gentleman from Cavite for bringing this on the floor, for availing of the privilege hour in order to have a healthy debate on this. Because indeed, the nation is entitled to know. And the gentleman is indeed fulfilling his duty as an elected representative of the people to bring this on the floor so that the people can be clarified as to what this agreement is all about. And I will repeat for the last time, what is the agreement that is binding on our country according to the good gentleman from Cavite?
Mr. President, for the end time, allow me to recast the propositions I laid down a while ago. One, if there was indeed an oral agreement, according to anecdotal news reports, that oral agreement would not need the concurrence of the Senate. That's what I mentioned, Mr. President. Reason number one is that that oral agreement is similar to the EDCA Supreme Court decision, which is part of the Mutual Defense Treaty concurred in by the Senate in 1952. The reason being is that the oral agreement, if there is indeed an oral agreement, is just part or an implementation of UNCLOS, which we ratified. So the mother agreement is UNCLOS, the oral agreement implements UNCLOS in the same manner as the EDCA implements the Mutual Defense Treaty, which has been upheld by the Supreme Court. But having said that, Mr. President, I think part of my speech would be the challenge to this august body to craft the needed legislation so that confronted with issues, similar issues such as this in the future, we may be able to draw the lines in pursuit of the concurrence power of the Senate. To be very clear, Mr. President, in the United States, there is Public Law 92403, if I may place this on the record, which would require the Secretary of State to transmit to Congress any oral agreement or even a summary thereof for scrutiny of the United States Senate. That is my point, Mr. President, when I ended my speech, that there is a lot of uncharted waters to be navigated by this august body, Mr. President.
Mr. President, the good gentleman from Cavite cited the EDCA to support the proposition that the Duterte-Xi Jinping agreement does not need concurrence of the Senate. First question, would the gentleman agree that at least in EDCA we know what the agreement is all about?
I agree, Mr. President.
And therefore, on the basis of that knowledge of what the agreement was all about, the Supreme Court said it does not need the concurrence of the Senate because it is only in implementation of the Mutual Defense Treaty. Do you agree, Mr. President?
I agree, Mr. President.
Now, but in this particular case, since we do not know what the agreement is, how can we come to the conclusion that it does not require the concurrence of the Senate when in the first place we do not know what the agreement is all about, Mr. President?
That is precisely my point, Mr. President. Since this is an oral agreement, we do not know the parameters, we do not know the metes and bounds, we do not know the contents. We rely on the political judgment, good faith decision of the President to fulfill his duty on what is good for the country, as stated in the case I cited a while ago, the Angara case, wherein the Supreme Court stated that it will not dwell, it will not put into scrutiny the wisdom, the judgment of the Chief Executive in entering into the World Trade Organization agreement several years ago, Mr. President.
Would the gentleman agree that any agreement, written or otherwise, must conform with the Constitution?
Yes, Mr. President.
Now, having said that, Mr. President, is it not logical that we know what the agreement is all about in order that we can judge as to whether this agreement is consistent with or contrary to the Constitution?
I agree, Mr. President.
If you agree with that, Mr. President, if you agree with that, Mr. President, is it not logical that we place on the record officially what is the agreement and the parameters of the agreement between the two heads of state in 2015 or 2016? Is it not incumbent?
Mr. President, I do not have in my possession the content of the alleged verbal agreement, but from the context of my speech, the difference between a verbal, informal treaty is that and a treaty concurred in by the Senate is that a verbal, informal treaty is of short-term duration, and in implementation of a bigger treaty to answer the exigencies of the times, Mr. President. That's why in my speech I mentioned, Mr. President, to refresh the memory of our colleagues, the instance concerning the Cuban Missile Crisis. If they needed a U.S. Senate ratification, negotiations, probably it would have resulted into World War III. Kung mag-uusap pa ho na matagal. Kaya ang nangyari po doon, verbal oral agreement, inutusan yung Attorney General, tapusin na natin to para matahimik na yung hemisphere na binanggit ko kanina. So meron po mga pagkakataon, mahal na Pangulo, na hindi po kailangan dumaan sa isang mitikuloso na pamamaraan kung saan bubusisiin ang lahat ng nilalaman. Pero naniniwala po ako, ang ating Pangulo, na ginagawa po ang kanyang tungkulin sa ilalim ng saligang batas, ay hindi naman po gagawa at papasok sa isang kasunduan na makakasira sa ating bansa. Yun po yung ibig ko po sabihin, mahal na Pangulo.
Thank you, Mr. President. Indeed, nobody is casting aspersion on the aspiration of the President to protect the Filipino people. What we are just looking at here is precisely what is this agreement, and if indeed it promotes national interest, it is consistent with the Constitution and our international obligations, we will be the first to support such proposition. But unless we have at least a reference point on what the agreement is all about, nobody knows whether or not this agreement is contrary to or consistent with the Constitution. It is in that aspect and context, Mr. President, that we are pleading with the gentleman to help us and help this institution perform its task by spreading into the record what this agreement is all about. Because after that, we can debate on the effects of a verbal agreement, and we can debate as to whether this verbal agreement is binding. We can assert as to whether, we can debate as to whether or not it needs the concurrence of the Senate. But until we know what the agreement is, we'll never be able to answer that question. All of us here are relying on media reports, including this representation. I am sure including the President of the Senate. But now that this matter is brought before the floor, this is an opportunity for us to have an official reference of the act of the President and not merely base the same on media reports. As a lawyer of note, Mr. President, the gentleman from Cavite will agree with us that until we have a definite pronouncement or at least record in the Senate of what this agreement is all about, it is extremely difficult to debate on the issue and come up with the proper policy formulation. That is our submission, Mr. President.
I concur with the gentleman from Iloilo, Mr. President.
Thank you, Mr. President. If the gentleman will concur, can we have the agreement stated on the record?
As I have mentioned, Mr. President, I don't have in my possession, nor do I have the capacity to secure agreements coming from mere saliva. I think the proper agency that would have to report here would be the Department of Foreign Affairs, if there is indeed such an agreement, considering they are the official repository of all treaties and international agreements entered into by our country.
I note that the gentleman raised the question, if indeed there is an agreement. Are we now not certain that there is an agreement? The gentleman just said, the DFA is the repository of knowledge and information. If indeed there is an agreement, are we now doubting the existence of the agreement, Mr. President?
Mr. President, as I mentioned several times, I am not in possession of the agreement, but consequent events after the alleged closure of the Scarborough Shoal led to the opening of the same area for Filipino fishermen. And the recent incident of June 9, 2019, concerning the collision incident of the vessel from Mindoro would show that some Chinese vessels are indeed present in our exclusive economic zone. And we have heard the Secretary of Foreign Affairs that such accommodation was by virtue of an agreement relative to the sharing, quote-unquote, provision allowed under UNCLOS. I have no possession, Mr. President, of any transcript or verbal agreement, and I agree with the gentleman from Iloilo that we don't have a copy of that. I was expecting that that would be the salient points of the State of the Nation address, but that was not the case. But be that as it may, what this representation raised a while ago would serve as our guideposts for future incidents, for future administrations, wherein the power of the Senate to concur would be put into question. What I'm saying, Mr. President, is that it is now time that we craft into law a legislation that would require the Department of Foreign Affairs to place it in black and white, all agreements, whether informal, formal, verbal, oral, implied, or what have you, into in writing, so as to comply with the Vienna Convention on the Law and Treaties, which would require that all agreements be placed in writing, Mr. President.
So, do I understand it, Mr. President, that the gentleman is calling upon the Department of Foreign Affairs to put in writing the verbal agreement between the President of China and our President, from that statement that the gentleman just made? Must now the DFA put it in writing?
I never mentioned that, Mr. President. What I mentioned a while ago, for the information of the gentleman from Iloilo, is that in the United States, they have a law. I mentioned a while ago, PL number 92, for PL number 92403, requiring the Department, the Secretary of State, to transmit to Congress any verbal agreement to which the United States is a party as soon as practicable, and I quote, after such an agreement has been entered into. What I'm saying, Mr. President, is probably there might be a gap in our current books concerning oral agreements. And to refresh again, the good gentleman from Iloilo, I'm sure he's familiar with this. The reason why secret agreements are banned is because during the Hitler-Stalin days, they have a secret agreement concerning the invasion of Poland and other European countries. So they crafted a law, they crafted a treaty requiring oral agreements to be placed in writing. But there are instances that would really require swift executive action, not necessitating the usual rigorous negotiations in the treaty-making process that would likewise require the lengthy deliberations in a body such as this, Mr. President. So I'm not saying that the DFA is required. What I'm saying is that we need to have a law put in place requiring for future reference that any oral agreement be placed in writing.
Now, this privilege speech, I assume, Mr. President, will be referred to the Committee on Foreign Relations. Can the chair of the Committee on Foreign Relations, the Honorable Pimentel, now issue a subpoena to the Department of Foreign Affairs, requiring the Department of Foreign Affairs to come before the committee and testify under oath what this agreement is all about?
Mr. President, I'm not at liberty to speak on behalf of the good senator from Cagayan de Oro. If this will be referred to the Senate Foreign Relations Committee,
On the basis of my little knowledge, after 21 years of being in the Senate, my little knowledge of the committee, of the rules of the Senate and the jurisdiction of the committee, I have no doubt that this will be referred to the Committee on Foreign Relations, headed by our good colleague, Senator Pimentel. So I just, assuming that this is true, or for that matter, assuming that we do not even have to cite Senator Pimentel, but can the chair of the Foreign Relations Committee subpoena the Secretary of Foreign Affairs and require him to put under oath and into the record of the Senate this verbal agreement between President Duterte and the President of China under the theory of the good gentleman from Cavite.
Mr. President, I assume that if ever this will be referred to the Senate Committee on Foreign Relations, in the exercise of its committee powers, I think the chair would accede to the suggestion of the good senator from Iloilo that that the Committee on Foreign Relations subpoena the good secretary of the Department of Foreign Affairs.
Yes, and would the gentleman, however, agree that in order that we can have a matter that we can discuss substantially and in substance, we must have the verbal agreement put into scrutiny by putting the same in the record of the Senate, at least to the Committee on Foreign Relations.
Mr. President, just to repeat again my answer a while ago, there is no existing law requiring that verbal, oral, implied, informal agreements be placed in writing.
There may be no existing law, Mr. President, but the power of Congress and its committees to issue a subpoena is within the power, is in the Constitution, and this is a legitimate piece, this legitimate congressional inquiry brought up by no less than gentleman from Cavite himself, and therefore an inquiry is perfectly within the bounds of the powers of Congress and the power to subpoena the Department of Foreign Affairs does not need an enabling law. That is an inherent power of Congress as sustained in a number of decisions for Congress to exercise, and failure to comply will expose the witnesses to contempt and deprivation of liberty, as Senator Gordon has so rightfully jailed a number of people for refusing to heed a subpoena of the Senate. And therefore, the power of the Congress to compel the Department of Foreign Affairs to come to the Senate and testify on this alleged agreement needs no legislation, with all due respect to the gentleman from Cavite.
The two gentlemen will allow. Senator Coco Pimentel is recognized.
Yes, thank you, Mr. President. With the permission of the two gentlemen, since the Committee on Foreign Relations was mentioned in anticipation of the referral of the privileged speech as well as the interpellation to the committee, for the information of everybody, we will constitute now the committee. I have complete. I will be submitting.
President, at a certain point, that is proper.
Yes.
I will be
submitting
the
it
period
now.
of interpellating on the speech. I think the matter of organizing the Committee on Foreign Relations can come afterwards.
Yes,
there is no harm in having it under after the speech.
I'm
Mr.
informing,
President.
Mr. President, that the committee will be fully constituted. Then we will wait for the referral. Then we will hear this on the
Thank you. Yes.
subject matter, which is actually the need. From what I get, this is actually on the need. On the need to enact a law to govern verbal agreements. But then the example used was the agreement between the alleged the verbal agreement between President Duterte and President Xi Jinping. So, and then we will follow procedure that we do not, as I understand Senate rules, we do not go directly to issuance of subpoena.
We did not. We were just citing the power of the committee in response to the need or to the assertion that we need a law to require the production of such agreement. What we're saying is, under the powers to issue subpoena, that kind of an agreement can be brought before the Senate and debated and produced because of the inherent power of Congress to issue subpoenas. We do not need the law about that, on that.
Yes, Mr. President, the hearing will precisely, with the cooperation of the executive branch, the hearing will now shed light on the executive department's position on the nature of the agreement.
Yes.
Yes, so if
that's
the
correct.
if from the
on
point
the
of
nature
view,
of the agreement,
yes.
How can we determine the nature of the agreement when we don't even know what the agreement is all about?
That's why,
That
Mr.
is why the first question, is the gentleman now taking over the floor and answering all the questions on the period of interpretation?
So, I will end- I will-
The last time I heard, it is the gentleman from Cavite who had the floor and he
So-
yielded it to this representation.
I just intervened, Mr. President, with their permission. So I will end my intervention, but I want to inform my colleagues and the Filipino people that I just met this morning with the chairman of the Committee on External Relations of the Communist Party of Vietnam. And I extended our thanks on behalf of the Filipino people to the Vietnamese people for saving our countrymen who were in distress at sea when they were abandoned after the ramming incident, Mr. President. Thank you
Mr.
very much.
President. Thank you. That's a very noble act on the part of the putative chair of the Committee on Foreign Relations. Thank you very much. So can we go back to...
Yes,
our-
the Minority Leader has the floor together with the Senator Tolentino.
I already forgot what my last question was, if there was any. In any case, Mr. President, I don't want the...
Well, the chair is just curious. We would like to pick the mind of the distinguished gentleman from Iloilo. What are the list of treaties or what have you that are submitted to the Senate based on the Constitution?
To answer that question, Mr. President, we must know what the agreement is all about.
Yes.
In my view, Mr. President, if the agreement seeks to change certain domestic laws, then you need the concurrence, ratification of the President, and concurrence by the Senate. For example, tax treaties, where you exempt from our income tax earnings of foreigners in our country through a tax treaty, that would require an agreement. Where the government under that agreement is bound to do certain acts, then you have to, or adherence to certain policies, then that is a treaty which needs the ratification of which would need the concurrence of the Senate. And in answer to your question, Mr. President, there is no fixed rule. We must determine on a case-to-case basis whether a document or an agreement is an executive agreement or a treaty that requires ratification. But the first issue is, before we can determine whether the document imposes an obligation or is merely an executive agreement, we must know the agreement.
Correct.
Hanggang ngayon po, hindi natin alam kung ano yung agreement.
Like you, Your Honor, we would like the definition of agreement as far as that verbal agreement is concerned,
Yes.
because we're supposed to ratify conventions, treaties,
Yes,
and agreements.
yes.
How do we define agreement in this case?
There is no, as I said, in my view as a lawyer, it's on a case-to-case basis. You must look at each agreement. There is no fixed rule. I can only think of general rules, like if the agreement changes certain domestic laws, then you must ratify. But as I said, I will repeat, it depends on a case-to-case basis what the agreement provides, because you have to determine what is incumbent or what is obligated, what is the obligation of the parties under the agreement. That is why we must know what the agreement is all about, Mr. President, in order to determine whether it is simply an agreement, international agreement, which does not need ratification of the Senate. For example, Mr. President, cultural exchanges where you exchange dance troops, yung mga sumasayaw, ipadala mo sa Russia o ipadala mo kung saan. Hindi po sa akin, hindi po kailangan ng ratification po yan. Dahil hindi naman kailangan ang mananayaw ay dadaan dito sa Kongreso. So, as I said, Mr. President, it depends on what the agreement is all about, but because in my view, there is no one rule that we can cite. But to determine that, we must have on the record what is the agreement. I don't think we can divine whether or not it is an international agreement, a treaty, or what have you, unless we know what the agreement is all about. So it is in that sense. But anyway, Mr. President, I still have a number of questions.
All right, you may proceed.
Yeah, we will suspend our period of interpretations. We can come back on another day to ask the questions before it's the referral of the speech to the appropriate committee.
Before we refer it?
Yes.
All right, all right. Then we'd like to recognize now Senator Pia Cayetano, who was earlier raising her hand.
Thank you, Mr. President. Very briefly, with the permission of the honorable gentleman from Cavite, I'd like to make a few statements and perhaps elicit a short response. With the permission.
Yes.
Willingly, Mr. President.
First of all, I'd like to commend the gentleman from Cavite for delivering his maiden speech. It was very informative, very educational. Aside from the overview he gave us on jurisprudence, he also gave us a very well-researched picture of international practices. And I had to ask for a copy of the speech from his staff because I was very interested, but I couldn't follow because there were so much interesting details. And I'd just like to make reference to the speech itself because I think it's so important. Because when I read the newspaper, I'm a little bit surprised that the only angle that I see is how we are allowing ourselves to be exploited by China and to some extent sometimes other countries. But it's very interesting that the perspective about the importance of international cooperation is very seldom mentioned or recognized. And so the speech of the gentleman from Cavite, to me, should really be highlighted. And I hope our dear partners in media would highlight this point that he raised, that all over the world, international cooperation is a given practice. He mentioned that in the Pacific, countries there have been working together. They have entered into multilateral fisheries management agreement in order to effectively utilize and manage their shared resources. He mentioned other Pacific countries that also recognize the importance of international cooperation. And then he mentioned countries like the United States and Canada that enter into agreement on the management of the Pacific salmon, other countries in Africa that entered agreement in the management of fishery resources, particularly in the Bengala large marine ecosystem, and then New Zealand and Australia in the management of the South Tasmanian rice, and so much more. The gentleman says the list goes on and on. And then he cites a World Bank 2016 study that shows that half of the world's exclusive economic zones are subject to some form of foreign fishing agreement, be it through access agreement, joint ventures, and even just chartering. This is just so interesting to me that we put this on record because, again, as I said, does the gentleman agree that you rarely hear about this when you read the news or when you listen to opinion makers make commentaries on this? Is my observation correct?
Mr. President, I agree with the statement of my colleague. And if I may add as a sidelight, the newly elected Prime Minister of United Kingdom, Mr. Boris Johnson, won, among other things, because of the Brexit issue. And, Mr. President, if we are to analyze current fishing practices in the United Kingdom, foreign fishing vessels are allowed to fish within English waters as far as near as 6 to 12 nautical miles, not even 200 nautical miles of their EEZ. Foreign fishing vessels, I'm referring to German fishing vessels, French fishing vessels, they could go as near as the baseline of London. And there is no even mention of security threats or economic implications. What we are seeing here is a heightened level of cooperation. But the new Prime Minister, Boris Johnson, probably would, because of their exit from the EU, will probably see change concerning this, and it would now revert back to the exclusive fishing jurisdiction of English authorities, Mr. President. So I agree with the lady, with our lady colleague, that heightened sense of cooperation is needed, just as we assert our ownership to that portion of the West Philippine Sea.
Well, it's interesting that you end on that note, that our colleague ends on that note, because that was the second and last point that I was going to, that despite our recognition of the importance of international cooperation, the reason why we recognize it is precisely to protect our own interests and the interests and rights of our fishermen, which I also would like to emphasize was I believe the primary objective of the gentleman here, that we are definitely putting at the forefront the rights and interests of our fishermen. And again, I would like to quote, just to reiterate, because I again found it so meaningful, because I don't hear it reported I don't hear it reported at all, actually. The gentleman goes on to say in his speech that we are a signatory of various international agreements, including the FAO, that is the Food and Agricultural Organization, which has required us to provide certain reports. And one of this, the gentleman mentions, is that while BFAR has set a catch ceiling limitations for tuna, the Philippines has not set allowable catch ceilings and has no data regarding the optimal catch in its EEZ. The failure to set these standards and to report information regarding the resources in the West Philippine Sea is detrimental to the conservation and management of the area. I cannot disagree, I cannot agree even more with this very basic statement. And again, I commend the gentleman for pointing this out to us. I join you in any efforts you would like the Senate to take to ensure that BFAR does this immediately. I'd just like to ask one point of clarification. It is my lack of understanding of the technical terms. When we say that BFAR has set a catch ceiling limitation, and yet the Philippines has not set allowable catch ceilings and no data on optimal catch in its EEZ, I'm assuming that these are details as to, there may be a ceiling, but it doesn't mean it's optimal for us. It doesn't mean it's sustainable. Is my understanding correct?
Mr. President, my lady colleague is correct, but to refocus on the lack of attention, alleged lack of attention being done by BFAR, ang ginagawa lang po nila is, since in 2012 yun last, to focus on just one fish, tuna.
Tuna lang, okay.
Tuna. The others,
Okay.
nasa Annex 1 po ng UNCLOS, hindi po nagre-report ang BFAR sa Food and Agriculture Organization. So yun po siguro yung lapses, kaya meron pagkukulang sa reporting system. Taon-taon po kasi may country profile ang bawat bansa. Ito yung total allowable catch. Sa Pilipinas po, tumigil na po tayo nung 2012. Hindi ko po alam anong kadahilanan sa BFAR, Mr. President.
Okay, thank you for that. I wasn't, so whether it's tuna, whatever the details are on the limitations and sustainability of our tuna, the point that His Honor is raising is that there are also other fish that we are not even aware of. It's interesting because I am predominantly a pescatarian, which means fish ho ang main na kinakain ko. And I've been reading a lot of reports that says that we're overfishing, and even for those, and there are more and more people as we become conscious of our health that are shifting to fish, and yet we do not know how long our fish supply will last. So I will end on this point. My interest here, Mr. President, is the fact that this goes into a committee that I will chair, which is the Sustainable Development Goals Committee. And SDG number 14 is life below the sea. So I join His Honor in his sa kanyang panawagan. Nakikiisa po ako sa inyo sa inyong panawagan that we look into these various Senate bills that His Honor filed and resolutions that he filed, because they really go into the sustainability of our food supply. This is very important because as we look into the potential that we will be a middle income and even a high middle income country in our lifetime, we want to ensure that we have a food supply that our countrymen can rely on. So thank you so much for His Honor for bringing this to the forefront. Thank you, Mr. President.
Thank you, Mr. President. With that,
Majority Leader.
we'd like to... Mr. President, our distinguished gentleman from the areas concerned, which is Subic and Zambales, would like to weigh in on the discussion. May we recognize Senator Richard Gordon.
Senator Richard Gordon is recognized.
Thank you very much, Mr. President. Will the gentleman yield just a few questions?
Willingly to my former colleague in the local government.
Mr. President, first of all, let me congratulate the good gentleman for bringing this issue to the forefront of the Senate, because this is something that is crying out for public appreciation and knowledge, Mr. President. And it is important that we are not left in the dark. I'm sure the gentleman has heard of the phrase, "the devil is in the details." Have you come across that statement?
Yes, Mr. President. Yes, Mr. President.
And what does that mean, Mr. President?
Insofar as this speech is concerned, probably the details on as how our colleague from Iloilo mentioned a while ago, to place the hubris of the oral agreement, to have that place in the Senate's scrutiny as well as the public appreciation. So that was never the intention, Mr. President, of this representation. What I propounded was the idea that if there was indeed an oral agreement, that oral agreement is akin to the nature of an executive agreement, which is not part of the Senate's concurrence turf. And I likewise propounded several recommendations, legislative measures that could be enacted by the 18th Congress to forestall and prevent similar incidents from arising, especially agreements concerning the West Philippine Sea and other agreements that affect the rights not just of this institution as regards the concurrence powers, but the ordinary Filipinos, Mr. President.
Is it my understanding, therefore, that you are recommending that we do not exercise our power of review or oversight over matters that involve national patrimony, national resources, or national security when it comes to this particular agreement? Because, like I said, the devil is in the details. And we would like to know, and I will follow this up with another question. Is that the position of the gentleman from Cavite?
Mr. President, that was never my position. The position that I mentioned a while ago is that the oral agreement that I mentioned was in execution of a mother treaty, the UNCLOS. Therefore, it would not require the concurrence of the Senate. But as to other oral agreements, verbal agreements, informal treaties that would arise in the future concerning perhaps OFWs, concerning perhaps taxation, concerning perhaps national security. The gentleman from Zambales is correct that the Senate has a right to inquire in the exercise of its broad oversight powers as to the terms of that treaty, Mr. President.
It's good to know that, although, of course, under the Article 12 of National Economy and Patrimony, the last line says, the President shall notify the Congress of every contract entered into in accordance with this provision within 30 days from its execution. Do you know if the President has done that already, Mr. President?
Mr. President, if the good gentleman is referring to Article 12, Section 2, there are several economic provisions. Perhaps the good gentleman is referring to the first provision concerning the utilization of our natural resources, entering into joint venture agreements with foreign corporations relative to energy. But, Mr. President, the interpretation of this representation is that it does not refer to fishing rights, sharing agreements provided for under, directly under the UNCLOS, which probably the gentleman from Zambales would agree, having ratified that, the Senate having concurred with that, is now forms part of the laws of the land. So, Mr. President, I think that because it is a long provision of article of Section 2 referring to several joint venture agreements, and that section, that paragraph that refers to the exclusive economic zone, which I consider sui generis, can stand alone. It need not be part of that whole article concerning joint venture agreements with other countries, because it refers to the sovereign rights of the Philippines to manage, conserve, and protect the resources of our territorial sea, the contiguous zone, and the exclusive economic zone, Mr. President. So perhaps the gentleman is correct. Perhaps the gentleman is correct that agreements concerning commercial, economic treaties would have to be reported by the President, but an agreement that has a verbal agreement as that has nothing to do with any commercial transactions probably would not fall within the purview of the clause cited a while ago with the good gentleman from Zambales, Mr. President.
Thank you, Mr. President. I would like just a quick answer here. Would the gentleman consider fisheries as part of our national resources?
Yes, Mr. President.
So in other words, this is part of Article 12, when you say if the President has a verbal agreement with China that they may fish even pursuant to UNCLOS, Mr. President, that's still part of our natural resources, and that the President is duty-bound to inform the Senate within 30 days what agreements is made in concerning natural resources. Would you agree?
Mr. President, again, no offense with due respect to the gentleman from Zambales, the current trend, especially, no offense to the members of the media right now, is to just lift the second paragraph of that very, very long article and make their pronouncements just relative to that portion which states that the state shall protect the nation's marine wealth in its archipelagic waters, territorial sea, and exclusive economic zone, and reserve its use and enjoyment exclusively to Filipino citizens. But it should be read together with other provisions, starting from the first paragraph, which refers to joint venture agreements which would require commercial transactions, and the last agreement similar to the first paragraph, Mr. President. So I think that has beclouded the current debate to lift just this portion that I mentioned a while ago and disregard the other provisions of that very long constitutional provision, Mr. President.
But Mr. President, no matter its length, the objective of the founding fathers, you will call them that, is to preserve the natural resources for the exploitation of our people, especially in these times where food security is always an issue in our country. And therefore, anything that has got to do with the exploitation of our natural resources, including fisheries, must be given by way of a formal notice by the President to the Senate. But proceeding from all that, Mr. President, let me go to my next question. Now, when you start talking about UNCLOS, isn't UNCLOS subordinate to the constitutional provision, Mr. President? It's only it's a treaty, but certainly it's ratified. But UNCLOS should be subordinate. When there's a disagreement, it should be the Constitution that should be taken up, not the UNCLOS alone. Nevertheless, UNCLOS is not an issue here, because the issue here is an agreement announced by the President that he has said has allowed China to have joint fishing or whatever it is that he wants to. My question now is this. How would the Coast Guard treat this now? Are they under orders from the President to allow the fishermen from China to fish in our waters now, Mr. President? How would our Navy treat this now, Mr. President?
Mr. President, with due respect to the gentleman from Zambales, considering that he arrived late, no offense, I already
Excuse me,
explained...
Mr. President, may I just, I do not want to insult the intelligence of the good gentleman, Mr. President. I arrived late simply because I was receiving a check for the Red Cross for people who are right now under a check right now. And
I apologize, Mr.
when I
President.
was there, Mr. President, my staff was here, and when I came here, I was properly informed. I think that is something we will all learn as we go on in the Senate, Mr. President, that our people are here to take note so that when we come in, we will be properly informed. I would like to think that that wasn't a remark that is made to disparage my attendance in the Senate, Mr. President.
I apologize, Mr. President, for that
Apologies
remark.
accepted, Mr. President. Thank you.
And that should be expunged from the records of these proceedings, Mr. President. I apologize to my colleague from Zambales. The first premise is UNCLOS on equal
May
footing.
we ask for a ruling of the chair first, Mr. President?
There is no objection. It's from the floor. It's expunged.
Thank you, Mr. President. The apology is accepted, and we're friends here, Mr. President. I just wanted to be sure that we all understand one another. We're coming from the same page here. Like I said, what is now the position now insofar as will the Coast Guard now be allowing them, Mr. President? In fact, this morning, I was gratified to hear that the President has said the Coast Guard should now protect our people in that area. Would that be accurate, Mr. President?
If I may answer the previous query, Mr. President, insofar as UNCLOS and the Constitution, I referred to the contents of my speech that the words exclusive economic zone was derived from UNCLOS, and it's an elementary precept in law that water cannot rise higher than its source. So EEZ was non-existent in the 1935 Constitution, non-existent in the 1973 Constitution, was placed in the 1987 Constitution after the 1982 UNCLOS was adopted. And precisely, Mr. President, that's the reason I cited the deliberations during the CONCOM, wherein the former Chief Justice Roberto Concepcion qualified the use and enjoyment exclusively to Filipino citizens by adding the term in the records subject to the general principles of international law. As regards the second query, Mr. President, I have admitted before our colleague from Iloilo that I have no concrete basis as to the parameters of the verbal agreement. But if that was the instructions given to our Coast Guard, by all means, the Coast Guard should be present within our exclusive economic zone of 200 nautical miles. Bali, ano na lang po ito? 188 nautical miles. Kasi pag kinompute nyo pa yung territorial sea, you have the 12 miles. So 188 nautical miles, the Coast Guard should be present to help protect the nation's marine wealth in our archipelagic waters, territorial sea, including the exclusive economic zone, Mr. President.
Shouldn't that also include the protection of lives in danger of storms or ramming of vessels when they're in the water? I think that should also be included. I mean, you don't need the 200-mile limit or 188 miles, as you say, that the Coast Guard must be duty-bound to do that. But nonetheless, that's beside the point here right now, Mr. President. My point now is this. If it is clear to us that there is I'm not sure whether it's clear. I'm not sure whether I'm clear that the gentleman from Cavite is proposing that there is an international agreement or there is an agreement between China and the Philippines already because of what the President said. What exactly are we proposing here?
I cited, like the good gentleman from Iloilo, I cited anecdotal news reports. It was never mentioned in the SONA, but the proposition of this representation is that it is about time that this August chamber forestall the repetition of any informal agreements that would necessitate the concurrence of the Senate by enacting appropriate, enabling legislation that would protect not just the rights of the Senate as an institution, but even Filipino fishermen. Mr. President, nalulungkot po akong sabihin na wala pala tayong batas kung magkaroon ng aksidente na may mabangga uli and hindi ni-rescue. The good gentleman is a distinguished member of the Philippine Red Cross, chairman at that. Alam niyo po yung Good Samaritan, alam niyo po yung tumulong, alam niyo po yun. Wala po tayong batas na pag merong naiwan sa dagat ay dapat tulungan. That's why I filed the Good Samaritan at law, Mr. President. So I think the good gentleman is very well apprised of this situation. Meron ng barko po ang Red Cross. We congratulate him for that at napakalaking tulong po yon sa ating karagatan.
In fact, Mr. President, we do have a law, and it is by way of an international agreement called the Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, Mr. President. That is a law. And therefore, my concern here is that does this include, are we exempting this particular incident and not exacting responsibility from Xi Jinping's people, who are, by the way, perhaps militia? Are we excluding that, Mr. President? Because it is important for us to understand the following things, for an example. Kung may agreement talaga, gaano ba karaming isda ang uhulihin nila? Kung may agreement ba talaga, dapat humarap dito sa ating Senado para sabihin, hindi nating mahuli lahat ng isda o ang dami-daming isda, pwede kayong pumasok dito. And yet, there are studies by UP that that area is already being fished out by a very voracious appetite of Chinese fishermen who have to feed their people, sell fish abroad, even go as far as Argentina to fish. And that is why we're very concerned, because we have to protect our exclusive economic zone. Dapat pinagtatanggol natin yan para hindi tayo maubusan ng isda, kundi mamahal lahat. Pati galunggong mamahal, di ba? So in other words, it is important that this be clarified. And I'm glad and I'm thankful, by the way, to the gentleman for bringing this issue, not because we want to put anybody here under the spotlight, but to really to find out what are the intentions of the President. After all, the President is duty-bound to clarify it. I want to know, ano ba pinag-usapan nyo? Yan ba, hanggang saan ba mangingisda yan? Tayo ba, papayagan ba sa kanilang bayan, sa kanilang lugar na mangisda? Eh, hindi ko alam po yan eh. Kaya nga, eto, nasagasaan tayo, sinasay ko yung law na sinasabi niyo, wala, na meron tayong tinatawag na suppression of unlawful acts against the safety of maritime navigation. It's also part na dapat nating enforce. So, kung magkaibigan tayo ng China, hindi po ba maganda sabihin ng Presidente, magkaibigan naman tayo, bakit naman iniwanan niyo yung tao yan? Eh, kayo magdidemanda pa kami. Hingin namin pa yung extradition dyan, because that is also allowed. Because this partakes of almost, attempted homicide or frustrated homicide, di ba? In terms of the frustrated homicide in the part of the fishermen, no? So, dapat ipairali niyan. Sasabihin niya, magkaibigan naman tayo. Kung talaga may kaibigan tayo, hindi na kita dapat hingyan. Sabihin mo na lang, huhulihin ko yan para ma-file natin yung kaso rito. At kailangan bang umabot doon? Hindi na. Kung talaga kaibigan natin ng China, tinulungan na tayo dyan, ma-identify yung mga taong sumagasa. Although, again, this proceeds from the issue that you raised. But these are all part and parcel of the rough and tumble nitong issue ng napakasalimuot nitong West Philippine Sea. Hindi ba? Dahil palagi mag-uuntugan tayo dyan eh. I'm sure the gentleman will agree with me. Pwede tayo mag-untugan ng Vietnam. In fact, ang Vietnam, meron pa silang milisya sa kanilang mga isda. Ang China may milisya, tayo wala. Pero nagkiklaim rin sila doon sa ating mga lugar, so maaari tayo magkauntugan dyan. Kaya dapat lahat ng gagawin dito sa West Philippine Sea, klaro-klaro sa Filipino people, That's why I expressed my elation na dealing up with the biggest, pati mga bata, maintindihan itong issue ito sa pamamagitan ng ating pag-uusap dito sa kasalukuyan. So, to my mind, the clarification that I would really expect is that if this is considered as an agreement, then the Senate has a right to find out ano ang pinag-usapan ninyo, hanggang saan ba yan, the boundaries, and we should be told that. And I think Senator Drilon is in the right direction when he asked, with respect, the Committee on Foreign Relations, na dapat subpoena. And I don't think we should go all to that, because that's why in the Committee on Rules this afternoon, we were saying dapat yung liaison officer ng Presidente rito, dapat nalalaman kung ano nangyayari dito para umabot sa kanya. Mr. President.
Mr. President, I must admit I'm not familiar with that suppression act, whether it's a product of international law or a local legislation. But if it's international law, we have to distinguish whether it's self-executing or now being implemented by local legislation. My proposed bill would even provide for court jurisdiction in terms of relative to the incident that transpired last June. But again, I refer to my main proposition that executive one, is the President allowed to enter into oral agreements? Yes. State practices, part of the international customary law, provides for that. Number two, if there is an agreement such as that, is it subject to Senate concurrence? If it's in implementation of UNCLOS, I submit, this humble representation submits that it is an executive agreement that is akin to the ruling in the EDCA case, which would not subject it to Senate scrutiny. But again, I agree with the good gentleman from Zambales that we provide, the DFA should provide the details, the scope, the parameters of that said oral agreement to enlighten the Senate if there is a need for a supplementary legislation that will buttress the said oral agreement. Mr. President.
Well, Mr. President, nobody disagrees that the President cannot enter into international agreements. He can. But we disagree in the fact that where the matter involves national security for one, or for that matter, commercial rights, or for that matter, other issues, the Senate has the right to find out what it is all about, in order that we will all be clear when we start demanding from the Coast Guard, why are you not acting on this matter, or why are we suffering for this? Why is the Department of Justice not pursuing the case against these fishermen? Because up to now, the names of the fishermen have not been stated. But you know, when you say you have a friendly agreement between two presidents, therefore, it partakes of the nature of a lot of influence by the President of the Philippines and the President of China with each other, and therefore they should be able to be more candid and more friendly in the handling of these problems. And that is why I think I go by my original statement that the President shall notify Congress of every contract entered into in accordance with this provision, or for that matter, any contract, because under Section 4, Article 18 of the Constitution, and I quote, all existing treaties or international agreements which have not been ratified shall not be renewed or extended without the concurrence of at least 2/3 of all the members of the Senate. That is why we are very concerned sometimes when agreements are submitted here by the Department of Justice or the Foreign Affairs, and sometimes we sit on it for 3, 4, 5 years. That has been known to happen here, Mr. President. And I agree with the gentleman that kung may ganon, dapat the Department of Foreign Affairs should write us a letter and say these are the current agreements that have been formulated, and we should know about it because that is part of our role under the Constitution. Mr. President.
I agree, Mr. President, with the commentary of the good senator from Zambales that the Senate should be informed of matters of national significance concerning treaties, more so if it relates to the 2/3 concurrence powers of the Senate, Mr. President.
Thank you, Mr. President. I have other questions, but I believe some of our colleagues have expressed their desire to deliver a privileged speech after this.
Yes.
So I will forego my questioning and do so at another time after I've read the speech as well. Thank you very much, Mr. President. Thank you very much, gentlemen from Cavite.
And by the way, there was a manifestation by the minority leader that he has suspended his interpellation and will continue at a later time. So therefore, we will just like to suspend the consideration of the privileged speech before referring it perhaps later or tomorrow if the interpellation will continue. So in the meantime, we recognize the majority leader.
He seems to be very well satisfied, Mr. President, coming from the refectory.
Thank you, Mr. President. We move to suspend consideration of the privileged speech of Senator Francis Tolentino, while I believe other members still want to continue asking clarificatory questions.
All right. Any objection? Hearing none. Interpellations are suspended.
Mr. President, we have another distinguished member who wants to deliver a privileged speech. May we recognize Senator Panfilo Ping Lacson, Mr. President.
Senator Panfilo Lacson is recognized.
Mr. President, I stand before you on a matter of personal and collective privilege. During his fourth State of the Nation address, we heard President Rodrigo Roa Duterte loud and clear. You are free to investigate. I don't take offense. If there's anything wrong in my department, the executive, you are free to investigate. Feel free to expose anything. In all of my years as a public servant and as a member of this revered institution, I have been unflinching in my fight against corruption and wrongdoings, blowing the lid of anomalous activities in the government, from the money laundering scheme by one Jose Pidal, the diversion of 728 million pesos in fertilizer funds engineered by one Joc Volante, COMELEC Commissioner Virgilio Garciliano's Hello Garci tapes, the botched $329 million contract between the Philippine government and China's ZTE for a national broadband network project, the chopper scam, where second-hand helicopters were sold as brand new to the Philippine National Police, the Tara list or payola in the Bureau of Customs, and the cholesterol-rich pork barrel, to name a few. Mr. President, hearing what we all heard from no less than the Chief Executive when he issued words of encouragement to us in a joint session of Congress last July 22, I could not help but respond to his call by talking to myself. Say no more, Mr. President. I did it many times before, and I will do it again as I do now. I will be presenting incontrovertible evidence. I leave it up to you to act in the same way that you have acted many times before, swiftly and firmly. We know for sure that we are on the right side of the fence when no less than the President of the Republic calls for the eradication of corruption and vows no sanctuary to sacred cows in the government. In corrupted offices, we tend to refuse to see the sacred cows, but when sacred cows become intolerable mad cows that bring transmissible, infectious, progressive, and fatal disease that continues to plague our country, an alert must be issued in no time. Hence, with the same unwavering tenacity as before, I round up the herd, find the mad cow, chop its flanks, cut off its horns, and hopefully lay it to rest. Lately, I discovered one that is ill and disgusting. I speak of the disease that besets our health sector, starting off from the state-run firm that provides public health insurance and health care services for all Filipino citizens, the corrupt and corrupting system of the Philippine Health Insurance Corporation, or PhilHealth. And while President Duterte has acted with firmness and dispatch by assigning retired Army Major General Ricardo Dick Morales, whose reputation as a no-nonsense and principled military officer precedes him, this humble representation still finds the need to expose shenanigans within PhilHealth, most of which were not covered by a recent series of jolting news reports in the Philippine Daily Inquirer and other media outlets. Mr. President, PhilHealth is bleeding dry, and the Commission on Audit has raised red flags to call our attention. It seems to me that year in, year out, its financial deficit spirals out of control. From 2013 to 2017, the net operating income of PhilHealth continues to be at the negative level. 5 billion in 2013, 1.8 billion in 2014, 5.7 billion in 2015, 6.1 billion in 2016, and 10.5 billion in 2017. Mr. President, the fund viability, membership, collections, and investments of the agency are not looking good, and the PhilHealth's actuarial valuation report of 2016 shows us a clear picture. The report exhorts, and I quote, PhilHealth will go through difficult times and will encounter crisis if the recommendations will not be implemented, unquote. The agency's performance is also dismal. 2017's performance scorecard shows that it gained an overall score of only 47.82% from the Governance Commission for Government-Owned and Controlled Corporations scoreboard. This is disturbingly lower than the target score of at least 90% for its appointed members to be granted performance-based incentives. More disturbing is the fact that the GCG scored PhilHealth's prosecution rate at 0%, arbitration rate at 0.14%, and claims processing rate at 0%. Ironically, PhilHealth's collection efficiency rate, meaning its ability to collect contributions from its members, is quite impressive at 79%. What gives? Mr. President, this is pain in the chest, especially of paying members of PhilHealth, and that would include people in this hall and the gallery and the rest of the 18,207,555 Filipinos who pay mandatory contributions every month. Meanwhile, more than one-third of the population still have no access to any form of PhilHealth insurance. PhilHealth is already operating at a loss, spending beyond its means, but where does the money go? Here's the paradox. The financial health of PhilHealth is fast deteriorating and, in fact, in a state of coma. The policies in place engender fraud and corruption, and the crooks exploit the system. There are several telling signs showing how PhilHealth wantonly drains the public coffers, but those in the highest echelons of power in the agency seem to turn a blind eye, aggravating the degenerate state of the agency. We see various culprits and incarnates. One is the highly contentious and untenable policy called all case rates, or ACR payment scheme. Simply put, PhilHealth pays per case and not by actual expenses. These case rates are the new reimbursement rates for all cases specified as professional fees and serve as package payment for health interventions to be paid to the healthcare providers or healthcare institutions. It is a complete departure from the prior fee-for-service payment scheme. Per PhilHealth Circular 31, Series 2013, all case rate policy number 1, the payment scheme is founded on one underlying objective: increase support value to members. Data from the 2014 Audit Observation Memorandum of the COA for Northern Mindanao shows us how the new case rate works. For example, in Bukidnon Provincial Hospital, Manolo Fortich, one patient treated for pneumonia registered actual hospital charges of only 4,820 pesos, but PhilHealth paid out 15,000 pesos, or an excess of 10,180 pesos. A PhilHealth-accredited private hospital, Bongkas Holy Child Hospital, also in Bukidnon, a patient with typhoid fever incurred 5,763 pesos, but PhilHealth paid out 14,000, or an overpayment of 8,237 pesos. A case of cesarean section surgery in Llano del Norte Provincial Hospital incurred hospital charges of 9,557 pesos and 95 centavos, but PhilHealth reimbursed with 19,000 pesos, a difference of 9,942 pesos and 5 centavos. From the said COA audit alone, of the total or of the 6,128 cases recorded, an appalling 20% accounts to overpayment. Hence, when PhilHealth's benefit claims reached unprecedented high levels from 2013 to 2018, using the all-case rate payment method, without an iota of doubt, something does not add up. In fact, the corporation paid 512.6 billion in benefit claims from 2013 to 2018, of which the overpayment, if conservatively pegged at 20%, based on COA estimates, would amount to 102.5 billion pesos. If we are to include the global estimates on losses to fraud due to improper payments computed at 10% or 51.2 billion pesos, we get an estimated PhilHealth losses to overpayment and fraud at 153.7 billion pesos. PhilHealth officials belatedly justify overpayments as nothing but, and I quote, efficiency gains. That is, hospitals that receive amounts in excess of their actual charges may use the funds to effect or to offset the losses they incur from other patients. In fact, former PhilHealth President and Officer in Charge, Dr. Roy Ferrer, casually dismissed the issue and said the case rates are so designed that so that health facilities can, and I quote, win some and lose some, unquote. Let me ask, win some for whom and lose some for whom? Between you and me, this justification is nothing but an afterthought, and it insults our common sense. By winning some, for some hospitals, do they expect us to accept it to mean PhilHealth losing some in billions of funds looted from the corporation? Let me indulge you with these findings. On pneumonia cases alone, the Bondok Peninsula District Hospital's actual charges are at a meager sum of 200,397 pesos, but PhilHealth has recorded a payment of 5,025,000 pesos, easily a 2,508% incremental difference. In the far-flung town in Sulu, the Siasi District Hospital only charged a total of 67,459 pesos, but as per PhilHealth records, it paid out 430,500 pesos to Siasi District Hospital, or a 638% increase. In the National Capital Region, GAT Andres Bonifacio Memorial Medical Center charged around 5.2 million pesos, but the PhilHealth recorded reimbursements reached 28.8 million pesos for a difference of 23.6 million, or overpayment of 556%. The 2013 to 2018 data, culled from PhilHealth dashboard, shows us that overpayments on pneumonia cases alone can balloon from a low of 387% to a high of 2,508% in government hospitals. They can call it any name, fancy or otherwise. Common sense will tell us these are not efficiency gains, but flagrant pillage of public monies as well as hard-earned contributions from the more than 18 million paying members. Private hospitals are likewise, quote, winning some, unquote. In fact, we found overpayments ranging from 100-fold to 700-fold higher than their actual hospital charges. All right. Let us assume for a while that efficiency gains is a sound and reasonable scheme to justify the PhilHealth's win some, lose some formula. Let us stretch our understanding that efficiency gains can benefit government hospitals, as these overpayments, if actually received by them, may trickle down to the general public who are mostly poor and vulnerable, or for procurement of additional hospital facilities, or for other noble purposes. Granting without accepting, are there parameters or guidelines or accounting of those overpayments? We tried hard to look, Mr. President. We cannot find any. And why would private hospitals be accorded the same efficiency gains or benefits and incentives they claim to be given to government hospitals? Again, we have some representative samples of private hospitals under the same efficiency gains scheme. Sa Region 10, ang Oligario General Hospital ay nakatanggap di umano, yon ay yung kung paniniwalaan natin ng PhilHealth, ng 38.2 million pesos mula sa PhilHealth. Samantalang 5.04 million pesos lamang ang ginasta at siningil nito. Nangangahulugang pumapalo sa 758% ang overpayment. Sa National Capital Region, ang Dr. Sabili Health Services ay gumasta at naningil ng 3.08 million lamang. Subalit sa record ng PhilHealth, 20.7 million pesos ang sabi nila ay naibayad. Kaya 673% naman ang naging overpayment. Samantala, ang Eastern Sun Medical and Diagnostic Center Incorporated ay may gastos at siningil sa PhilHealth, may siningil sa PhilHealth na 4.7 million lamang. Pero ang PhilHealth naman, base sa record, ay nagbayad ng 29.6 million, kaya higit 628% naman ang sobrang bayad. We can go on and on with our list, Mr. President. Kaya lang, it may be hazardous to our health. Baka ma-high blood lang tayong lahat. PhilHealth boldly claims that these health institutions actually receive these are normally high overpayments. But I couldn't help but wonder, with nothing but words from PhilHealth officials, how can we take those words when there is no showing that these hospitals actually receive the overpayments? Overpayments are monies that invite fraud and corruption. No one keeps track where it goes, which health programs it funds, which health members it benefits. We already heard of the massive fraud perpetrated by the modus operandi of WellMed Dialysis and Laboratory Center Corporation. Ang mga lumantad na whistleblowers ay nagpahayag na nagsusumite ang WellMed ng peking benefit claims at ang nakakagalit pa sa lahat, ang paniningil ng WellMed sa mga PhilHealth ng gastos para sa dialysis ng mga pasyenteng nangamatay na. In response, PhilHealth officers claimed that payment to WellMed was cut as early as January 2019 following reports of anomalies. Pero binobola lang pala tayo, Mr. President. Business as usual pa rin ang WellMed sa pagkubra ng reimbursements. Sa katunayan, base sa nakuha naming datos sa PhilHealth dashboard ng Central Office, mula Enero hanggang Hunyo 2019, ang kabuuang reimbursements ng WellMed ay pumalo pa rin sa 4.24 million pesos. Noong nakarambuan lamang, kumita pa rin ang WellMed ng 1,224,600 pesos mula sa PhilHealth. Ang saya-saya nila, Mr. President. Not only did WellMed continue to receive payments, it was also paid in record speed with turnaround time as short as 2 days at the time when the fraud was already made public. Kanino ba nagmamano itong may-ari ng WellMed at tila napakalakas? Marahil kung makakabangon lamang ang mga dialysis patients na namatay at nailibing na, at kung hindi pa nabuko ay patuloy pa rin pinagkakakitaan ng WellMed, ewan ko na lang kung sino-sino ang una nilang dadalawin para pagsasasakalin. Hindi lamang ghost patients mayroon ng PhilHealth, mayroon din silang overstaying patients o mga pasyenteng pinapauwi na ng doktor, kung bakit ayaw pang pauwiin ng ospital para lamang mapagkakitaan pa ang PhilHealth. Ang masama, tila kinukonsinti pa ng ahensya ang ilang mga ospital sa mga kalokohan nito. A case in point is the Perpetual Soccer Hospital based in Cebu, which was found guilty of extending confinement to siphon PhilHealth funds. In 2011, the hospital filed benefit claims extending the period of confinement of 2 patients with intent to defraud PhilHealth. For one, instead of recording the hospital doctors may go home order on 22 July 2011 for patient, let's call her Maria. Perpetual Soccer Hospital filed for her confinement a day longer. Meanwhile, another patient, let's refer to him as Jose, whose confinement covered inclusive dates of December 25, 2010 to February 3, 2011, as reported to be confined until February 7 or a 4-day confinement extension. Due to this, the PhilHealth Arbitration Office adjudged Perpetual Succor Hospital guilty of extending period of confinement and meted the penalty of 3-month suspension and a fine of 10,000 pesos. As part of due process, the hospital filed a motion for reconsideration with the PhilHealth Board of Directors, which, in the exercise of its quasi-judicial powers, denied the motion and upheld the arbitrator's decision. Consequently, a petition for review was filed by the hospital with the Court of Appeals. Finding no merit, the Court of Appeals Division dismissed the petition, and the motion for reconsideration filed by the hospital was likewise denied. An entry of judgment was made by the Court of Appeals on April 19, 2018, which means that the petition has become final and executory and recorded in the Court of Appeals Book of Entry of Judgments. Despite this, the PhilHealth Board, acting on a letter request for reconsideration filed by Perpetual Succor, in a brazen display of grave abuse of discretion, set aside the final executory judgment of the Court of Appeals and instead imposed the penalty of 100,000 pesos fine in lieu of the penalty of 3-month suspension and a fine of 10,000 pesos. Imagine this, para sa isang ospital tulad ng Perpetual Succor na kumukolekta sa PhilHealth ng hindi bababa sa 30 milyong monthly average na koleksyon, ano na lamang ang halaga ng 100,000 pesos na multa? Ako na rin ang sasagot, Mr. President, barya. Dahil sa 3 buwan na dapat ay suspendido ang Perpetual Succor Hospital, ay halos 100 milyon ang malamang na nakolekta nila mula sa PhilHealth. Perpetually lucky. One may ask, can the board legally do it? What is its legal basis and authority in overturning a final executory judgment rendered by no less than the Court of Appeals? Why would the PhilHealth Board even do that, Mr. President? Maybe the better question is, magkano? I know that PhilHealth has so much on its plate. The issues of overpayments and fraud are just a prelude to its telltale chronicle of shenanigans and corruption. Speaking of a tale of woe, PhilHealth faces another fiasco as plunder raps were filed against Health Secretary Francisco Duque III and his brother and attorney Gonzalo Duque. The case involves lease contracts that PhilHealth entered into with the Educational and Medical Development Corporation, where the Duque brothers own shares. Frankly, when I tripped on this anomaly in June of this year and called it a clear case of conflict of interest, I never thought I would hit a nerve so bad that Gonzalo Duque, a lawyer, would call me names after dismissing the issue of conflict of interest. It was a banter of poor taste born out of anxiety and how anxious he must be. Documents show that PhilHealth's Region 1 office had rented a building owned by the EMDC on Francisco Duque Jr. Street, Tapuac District in Dagupan City, from June 2012 to December 2018. The lease payments of the Duque-owned building with a total floor area of 1,853 square meters steadily increased through the years, from monthly lease of 368,500 pesos in 2012 to 432,305 in 2016. The contract for a year, or for the year 2018, was amended to cover 2,015.4 square meters, and the monthly rental was set at 529,261 pesos and 4 centavos. Copies of EMDC's General Information Sheet in our possession show that Secretary Duque was among the 8 stockholders of the company, all of whom are from the Duque clan. His siblings, Attorney Gonzalo Duque and Dr. Luz T. Duque Hammersheim, held the position of EMDC president, exhibited in various lease contracts with PhilHealth. Clearly, at the time PhilHealth was paying sums of lease payments to the Duque-owned building, Dr. Francisco Duque directly held concurrent positions in their family corporation and high-rank government posts, which created an undeniable conflict of interest. Noong 2012 lamang, or habang siya ay nakaupong Executive Vice President ng EMDC, siya rin ang Chairman ng Civil Service Commission, nakasabay na naglingkod bilang ex-officio member ng PhilHealth Board of Directors. Bukod pa rito, habang siya ay consultant ng Department of Health mula May 2015 hanggang June 2016, tumayo rin siya bilang presidente ng EMDC. A Supreme Court ruling, Funa versus Duque, Executive Secretary, Office of the President, under GR number 191672 on November 25, 2014, declaring as unconstitutional Civil Service Commission Chairman Duque's designation as ex-officio member of the PhilHealth Board, notwithstanding the effects of his acts prior to the declaration of the unconstitutionality of the executive order, and I quote, cannot be erased, ignored, or disregarded, unquote, applying the doctrine of operative fact. Ang pinakalantarang paglabag sa mga umiiral na batas ay ang pagpapatuloy ng kontrata sa pagitan ng EMDC at PhilHealth sa kabila ng pag-upo ni Dr. Duque bilang kalihim ng Department of Health at kasabay nito bilang chairperson ng PhilHealth simula noong Oktubre 2017. Ang EMDC ay nagpahayag noong Hunyo 2019 na wala na itong intensyong palawigin ang kontrata ng pag-upa ng PhilHealth na magtatapos sa Disyembre 2019. Pero ginawa lamang ito pagkatapos na mabulgar ang issue ng conflict of interest na nakapaloob sa kontratang ito. Ang gusto ba nilang sabihin, utang na loob pa ba natin sa pamilya nila na hanggang Disyembre 2019 na lamang magbabayad ang PhilHealth sa EMDC? Kaya naman hanggang sa mga sandaling ito, Mr. President, nagaganap pa rin ang conflict of interest. Pakisagot nga, Attorney. Mr. President, I wish to reiterate under Section 3I of RA 6713 or the Code of Conduct and Ethical Standards for Public Officials and Employees, and I quote, conflict of interest arises when a public official or employee is a member of a board, an officer, or a substantial stockholder of a private corporation or owner, or has substantial interest in a business, and the interests of such corporation or business, or its rights or duties therein, may be opposed to or affected by the faithful performance of official duty. Under Section 7, Prohibited Acts and Transactions of the same Republic Act, Paragraph A, financial and material interest. Public officials and employees shall not, directly or indirectly, have any financial or material interest in any transaction requiring the approval of their office. In the case of the Duque-owned family EMDC, if the case of the Duque family-owned EMDC is not a case of conflict of interest, I do not know what else to call it, Mr. President. Going back to Attorney Gonzalo Duque's anxiety, I will quote his unwise and reckless words, directly referring to this representation. He said, without mincing words, hindi mo magigising yung may purpose o nagtatanga-tangahan. Walang ospital para sa tanga. Mr. President, distinguished colleagues, I could not agree more with Gonzalo Duque. Totoo namang walang ospital na makakagamot sa isang katulad ni Gonzalo. Mr. President, the discovery of ownership of the building is in Dagupan being leased by PhilHealth has opened up yet another Duque-owned can of worms. It is called Doctors Pharmaceuticals Incorporated. Mr. President, distinguished colleagues, this time I invite your attention to another lucky business entity, that is the Doctors Pharmaceuticals Incorporated, a drug manufacturing company located at number 8 Veteran Center, West Bicutan, Taguig City, owned by who else but the family of the Secretary of Health himself, Francisco T. Duque III. Based on our data sourced from the Philippine Government Electronic Procurement System, or PhilJEPS, Doctors Pharmaceuticals Incorporated, with active platinum membership is an accredited corporation that bids for government contracts primarily with the Department of Health since year 2005. Ask a moron if there is something wrong with this situation, and surely that moron will give you the correct answer, Mr. President. That said, my office was able to acquire the general information sheet of the company covering a 10-year period from 2008 to 2018. Under the list of directors, officers, and stockholders of Doctors Pharmaceuticals Incorporated are very familiar surnames. Cesar T. Duque, Chairman with 60% shares. Joyce Ma Duque, Treasurer with 20%. Dr. Luz Duque Hammersham, President with 10%. A certain Leon Guerrero, Corporate Secretary with 8%. Please let us know if this is you, Senator Lapid. And Maria Teresa S.P. Castro, Chief Accountant with 2%. Evidently, Mr. President, only 10% of the total shares belong to the non-Duque personalities from the list provided. First, we ask, Mr. President, is it just a mere coincidence that Doctors Pharmaceuticals Incorporated became an accredited government contractor and supplier on the same year that Secretary Duque was confirmed by the Commission on Appointments as Secretary of Health during the Arroyo administration in 2005. Further, Mr. President, we have noted a number of suspension and product recall orders released by the FDA, or the Food and Drugs Administration, to Doctors Pharmaceuticals Incorporated. This was during the incumbency of former Health Secretary Janet Garin, who was also Acting Director General of the Food and Drug Administration in concurrent capacity. In fact, I asked her if she knew at the time that she was suspending a Duque family-owned corporation. She did not. Based on a routine inspection conducted between March 10 to 12, 2015, the FDA reported non-conformance to GMP, or Good Manufacturing Practice of Doctors Pharmaceuticals Incorporated, hence ordering the company to immediately cease and desist from further manufacturing, distributing, and offering for sale all concerned products for not complying with good manufacturing practice. She also discovered that Doctors Pharmaceuticals was also manufacturing for other companies. Hence, the June 23, 2015 cease and desist order and the recall of all drug products from March 14 up to the present, or on June 23, 2015. However, the FDA noted in January 2016, through an investigation prompted by an anonymous complainant, that Doctors Pharmaceuticals continued its production line despite the cease and desist order. The same inspection report recommended thereafter that the company stop production and distribution of pharmaceutical products until sufficient data was presented to prove that there was no contamination, and that the same were safe for consumption, as in the case of amoxicillin, an antibiotic that the Doctors Pharmaceuticals was manufacturing with the same machines which they used to manufacture supplements such as Garcinia, a supplement used for weight loss. Hence, if consumers took the supplement, they might also be unknowingly taking antibiotics. The danger lies in that persons allergic to amoxicillin could be put in danger. Worse, if the antibiotic was consumed in suboptimal amounts, it could contribute to serious problem of antibiotic resistance. Antibiotic resistance has been identified by the World Health Organization as one of the most serious and dangerous issues the world is facing. Halimbawa, isang kasama natin dito sa Senado, si Senator Bato de la Rosa, ay gusto magpapayat, kaya umiinom siya ng juice na may Garcinia supplement. Pero lingid sa kaalaman niya, iisang makina lang ang ginagamit ng kumpanyang nagsusupply sa DOH ng pagtimpla ng Garcinia food supplement at amoxicillin na isang antibiotic. E nagkataong allergic pala sa antibiotic si Senator Bato. Napakadelikado po nito. Baka sa halip na pumayat si Senator Bato, baka hindi na siya tubuan ng buhok. Pasensya ka na, Ronald. Wala na yung mista ko, nasa DICT na, ikaw lang ang kaya ko dito. Levity aside, Mr. President, yan po ang naging violation ng doctors, pharmaceuticals, kaya sinuspinde noong Marso 2015. Despite the recorded violations of the company as food supplement manufacturer, it still managed to apply and acquire automatic renewal of its license to operate in 2016. This is a case of setting aside health for wealth, Mr. President. When the pharmaceutical company that is awarded contract to supply medicines to the Department of Health does not observe good manufacturing practice in the manufacture of its medicines, does this not pose a threat to the health and safety of our public? Bear with me, Mr. President, I could not help my investigative instincts. Was doctors, pharmaceuticals actually setting aside health for wealth? In our efforts to dig deeper and convince ourselves with evidence involving this corporation, we referred to the PhilJEP's database to see and examine the contracts granted to doctors' pharmaceuticals. Strangely, Mr. President, we were able to extract only 5 copies or 5 notices of awards from December 2016 to July 2017 because PhilJEP's website went offline for an unusually long period of time. Anyway, examples of such award notices are as follows. Award notice abstract reference number 155775 and award notice abstract reference number 1557777. Awarded to Doctors Pharmaceuticals Incorporated, contact person Cesar T. Duque, President, for procurement of clozapine with a contract amount of 395,040 pesos and 3,102,000 pesos respectively, with contract award date 24 July 2017, both under contract number GOP 2017-060193, with contract effectivity date 13 September 2017, and contract end date 13 November 2017. Another award notice abstract, reference number 1377959, has an award date 08 December 2016 and contract end date 31 December 2017. Take note that Secretary Duque was appointed DOH Secretary last October of 2017. As a former chairman of the Civil Service Commission, Secretary Duque, more than many of us, should know by heart the Code of Conduct and Ethical Standards for Public Officials. Is it not incumbent upon Secretary Duque to exercise professionalism and ethical standards by stopping all dealings of his family's corporation with the very government agency that he heads? Mr. President, even the Supreme Court itself has made clear that the observance of professionalism in the context of Section 4A, paragraphs A and B of RA 6713 or Code of Conduct and Ethical Standards for Public Officials and Employees means upholding the integrity of public office by endeavoring to discourage wrong perception of their roles as dispensers or peddlers of undue patronage. Thus, a public official or employee should avoid any appearance of impropriety affecting the integrity of government services. Another standard set forth by the same law through Section 4, paragraph C provides that public officials must act with justness and sincerity. It further expounds that, and I quote, they, public officials, shall not dispense or extend undue favors on account of their office to their relatives, whether by consanguinity or affinity, except with respect to appointments of such relatives to positions considered strictly confidential or as members of their personal staff whose terms are coterminous with theirs, unquote. In a speech by then Civil Service Commission Chair Francisco Duque III during the Good Governance Forum on July of 2014, he said, and I quote, In government, it is important to care enough so as to stop or stem unethical practice or practices before they become ingrained or systemic. The more we let things pass, the more ethical standards get lowered. Secretary Duque's words, not mine. Mr. President, let me make it clear and put on record, walang personalan. I raise these questions to ensure that public funds are not misused and abused, and that the health and safety of the public are not put at risk for personal or family interest. Mr. President, we are about to fully implement Republic Act number 11223, or the Universal Healthcare Act, which will give a full spectrum of health services to all Filipinos. With it comes a big chunk of our annual budget. The budget appropriated for this landmark law is pegged at 257 billion pesos for this year. In fact, the National Health Insurance Program, or NHIP, in which every Filipino shall be a member under the UHC, had appropriations of 52.2 billion and 60.6 billion in 2017 and 2018, respectively. And for this year, 67.35 billion has been allocated for the program. We cannot afford to lose 1 peso from policy failures, insurance frauds, and conflict of interest. Besides, Mr. President, these are the country's PhilHealth and Department of Health that we are talking about, not PhilWealth and Department of Wealth. Be that as it may, Mr. President, I refuse to believe that the agency is rotten to the core. In fact, I have heard of many honest and well-meaning PhilHealth officers and employees who braved the odds and blew the whistle on these various anomalies in the corporation. But they all found themselves thrown under the bus and harassed with concocted, fabricated offenses. They may now find comfort under the new leadership. I urge them to report everything they know and present their evidence to their new PhilHealth president. From all these accounts, we see that like a biological organism, machinations on the misuse of public power for private gain continue to evolve, thrive, and linger. Amid these shenanigans, it behooves public servants, let alone the Secretary of Health, to rid himself of conflict of interest and put the interests of the people above everybody else. Nothing else will suffice. Falling short of this will compromise his office, principles, and integrity. Someone once said, "Greed is a bottomless pit which exhausts the person in an endless effort to satisfy the need without ever reaching satisfaction." Sadly, Mr. President, greed in this country has reached new greater heights. It is now at the expense of the people's health, one that is considered a fundamental part of our basic human rights. Finally, I say with no reservation, corrupt public officials have no place on earth, but corrupt officials stealing health funds deserve an upgraded and super special suite in hell. Having said all that, I move that my privileged speech be referred to the Committee on Health and the Committee on Public Accountability of Public Officers and Investigations. Thank you, Mr. President.
The majority leader is recognized.
Thank you, Mr. President. Mr. President, I just was curious because I also saw the province of Bukidnon there and other hospitals in Mindanao. How do they do would the gentleman yield to just a few questions?
Of course, willingly to the distinguished majority leader.
Thank you, Mr. President. On the issue on the overpayments, clearly it's unethical, clearly it is illegal. But the question that I'd like to place is, how would they take advantage? Let's say there are corrupt PhilHealth officials. Would the gentleman know on how they would take advantage of this overpayment? Would it be through a rebate scheme? Would the hospitals involved come up with a rebate scheme?
Well, your guess is as good as mine. The fact remains that there are overpayments, and this is not just overpayments, but overpayments in the amount of 2,500% incremental difference, Mr. President. That's unconscionable.
Do the whistleblowers that the good gentleman from Cavite discussed give a hint on how it's done? So that
Well, I think that would be a big challenge to the new PhilHealth president, who incidentally is here in our midst, Mr. President. So, General Dick Morales. So, that's why in my privileged speech, Mr. President, I enjoined the members of PhilHealth, those, because, you know, this information, most of this information came from them actually. They braved the odds, as I mentioned, to report all these shenanigans. And it is now their opportunity to report with their evidence to their new PhilHealth president, who I have known to be a man of integrity, a no-nonsense military officer during his time in the service, Mr. President.
So, Mr. President, with the revenue-generating measures that we've approved in the last 2 years, especially beefing up the coffers of PhilHealth, we congratulate the gentleman from Cavite for bringing this up, because we really need an efficient method of dispensation of these funds, or else all hell will break loose. Kawawa talagang taong bayan, and ang kawawa dito po yung mga nangangailangan ng tulong. So I congratulate the good gentleman from Cavite. We join him and we support him in this crusade to rid the agency, not only of PhilHealth, but also the Department of Health, of these corrupt practices. With that, Mr. President, we move that the speech of the gentleman from Cavite, Senator Ping Lacson, be referred to the Committee on Accountability of Public Officers and Investigation and the Committee on Health. It's a joint
The
hearing.
original motion of Senator Lacson is be referred to the Committee on Health, and then secondarily to the Committee on Accountability of Public Officers.
Traditionally,
I suggest
Mr. President, traditionally, it's usually the Blue Ribbon Committee that heads the investigation. But if there's no objection from the chairman of the Blue Ribbon Committee, I see no reason that the Health Committee be. May we recognize the Minority Leader?
The Minority Leader is recognized.
Mr. President, at the meeting today of the Committee on Rules, one of the issues that we discussed is the issue of the referral of speeches, of bills, of resolutions. And our agreement with the, if I recall correctly, is that the referral will be governed by the jurisdiction defined in the rules. And so that we avoid exercise of discretion, we avoid misunderstandings, and we can rely on the rules. So it is not a question of the permission or concurrence of anyone, but it's a question of whether or not they would fall under this or that rule. In this particular case, Mr. President, since it would appear that the principal thrust of the speech of the gentleman from Cavite is on the anomalies in PhilHealth, our respectful submission, Mr. President, is that it should be referred to the Blue Ribbon Committee primarily, and secondarily to the Committee on Health. We so respectfully move, Mr. President.
The gentleman from Iloilo is absolutely correct, Mr. President, citing that all matters relating to, including investigation of malfeasance, misfeasance, and nonfeasance, is the direct concern of the Committee on, or the Blue Ribbon Committee, Mr. President.
All right, then we will treat the manifestation of Senator Lacson as a suggestion, and that we will act on the motion of the Majority Leader, which is that it be referred to the Blue Ribbon Committee and secondarily to the Committee on Health. And just to say again, for the record, from the Chair, that we need indeed speedy action, and as much as Senator Lacson mentioned that the new President is here. If you will recall, during the time we were discussing the budget of the Department of Health, particularly the PhilHealth, I brought to the attention of PhilHealth then this particular neurologist in Corondal City, Dr. Mark Dennis Benguita, Region 12 PhilHealth, who has been conducting the same anomalies that were reported. And we have not received any report from PhilHealth from then up to now. So please include it in the referral to the Committee on Blue Ribbon and Committee on Health. So, any objection to the motion? Chair hears none. Motion is approved. So referred.
Thank you, Mr. President. Mr. President, another distinguished gentleman of ours, Senator Joel Villanueva, would like to deliver a privileged speech. May we recognize the gentleman from Bulacan.
Senator Joel Villanueva is recognized.
Thank you, Mr. President. Thank you, distinguished Majority Floor Leader. Arise on a matter of personal and collective privilege. The book of Proverbs 21, verse 15, it says, when justice is done, it brings joy to the righteous but terror to evildoers. Ginoong Pangulo, mga ginagalang kong mga kasamahan dito sa Senado. Naantala po ang inaasam na tagumpay ng manggagawang Pilipino laban sa Endo. Noong pong ika-26 ng Hulyo ay urong-sulong na ipinahayag ni Secretary Panelo ang pagvito ng Pangulo sa ating Security of Tenure Bill. Mr. President, let me spread into the records that we are not here to question the right and the prerogative of the President to veto the measure. Mr. President, however, I lament the rejection of the Security of Tenure Bill on account of the President's veto message. Ang 2 pahina pong mensahe ng Pangulo tungkol sa pagpapawalang bisa ng Security of Tenure Bill ang pinakamatagal ko na po yatang binasang liham. Ito po'y dahil sa labis kong kalungkutan at panghihinayang at sa kakahanap rin po ng partikular na probisyong nagtulak sa pagvito nito. I share the observation of our Senate President Pro Tempore, Senator Ralph Recto, that the veto message failed to specify the provisions that prompted the rejection of the Security of Tenure Bill. Sa halip po na ituro ang mga nireject na provision sa SOT Bill, ang nakita lamang po natin ay ang pagbibigay ng pangkalahatang dahilan kung bakit vinito ang panukalang batas na inaprubahan ng buong Kongreso. Una po, Ginoong Pangulo, nakasaad po dito na labis daw pong pinalawig ng Security of Tenure Bill ang katuturan at sakop ng labor-only contracting at security of tenure na katumbas ng pagbabawal sa kontraktualisasyon. Mali po ito, Ginoong Pangulo. Mas naging malinaw pa nga po kung ano ang mga pupwede po nating gampanan ng mga lehitimong job contractors sa panukalang batas na ipinasaho ng Kongreso noong 17th Congress. Ito po'y kumpara, Ginoong Pangulo, sa nangyayari po sa ngayon. Ito rin po, at nais ko pong bigyan diin, Ginoong Pangulo, ang definisyon ng labor-only contracting na sinertipikahan ng ating mahal na Pangulo noong 2018. Ikalawa, bagamat kinikilala po na dapat ipagbawal ang labor-only contracting, dapat pa ring payagan ang lehitimong pagkokontrata ng trabaho, ito man ay directly o hindi directly related sa negosyo. Tumugon po tayo, Ginoong Pangulo, at nauunawaan po natin kung gaano kahalaga ang work flexibility sa ngayon. Kaya nga po, binigyan natin ng kapangyarihan ng panukalang batas na inaprubahan ng Kongreso ang mga Industry Tripartite Council upang sila po ang magsabi kung anong mga trabaho ang directly related at kung ano naman ang mga trabahong pwedeng i-contract out. This is in recognition, Mr. President, of the fact that might be directly related now may not be directly related in the future in the light of rapidly changing technologies. Naglagay pa nga po tayo, Ginoong Pangulo, sa SOT Bill natin ng klarong basehan para limitahan ang discretion ng mga labor inspectors at korupsyon. Bentaha po ito sa mga mamumuhunan at negosyo at ito rin po ang request nila. Pangatlo po at huli, sisirain daw po ng Security of Tenure Bill ang delicate balance sa pagitan ng labor at management. Kalaunan, magdudulot daw po ito ng negatibong konsekwensya sa kapakanan ng mga manggagawang Pilipino. Ginoong Pangulo, kailanman hindi po ito ang naging intensyon ng ating panukalang batas na iniprubahan ng buong Kongreso. Bakit kailangan po nating isakripisyo ang kapakanan ng ating mga manggagawa at pahintulutan ang patuloy na pang-aabuso sa kanila ng mga mapansamantalang negosyante? Ayaw lang po natin, Ginoong Pangulo, ng fly-by-night contractors. Ayaw lang po natin, Ginoong Pangulo, ng walang responsibilidad o accountability ang mga contractors. Mr. President, I lament the veto message on account of the legislative process. Let me also agree with the good majority floor leader when he reminded everyone that the Senate leadership was being pressured, claiming that we have not acted on the SOT bill after the House of Representatives has passed their version and the Palace has come out with a certification that it was a priority measure, alleging further that we in the Senate has been sitting on it. Nakaka-pressure naman po talaga dahil paulit-ulit itong binabanggit ng ating Pangulo sa mga events, sa Labor Day celebration, sa nakaraang SONA, at ang pinakamatindi po sa lahat, ito po mismo ang sinertipika ng ating Pangulo as urgent and priority. Like you, Mr. President, I'm totally bewildered on this new development. Does it mean now, Mr. President, that the certification from the Palace actually is meaningless? If that is the case, Mr. President, then we have been misled as we have dedicated so much time. In this case, Mr. President, not only time, resources, energy, etc. We work on this particular measure for more than 3 years, Mr. President, to actually deliver the priority measures. Ito pong Security of Tenure Bill. At hindi lang po ito, kasama na rin po ang COCO Levy Bill, only to be told that they are not necessary. Ganito rin po ang sentimento kanina ng mga membro ng Committee on Rules. Kanina po sa pagpupulong, nandun po si Senator Drilon, Senator Lacson, Senator Win, Senator Pacquiao, Senator Angara, Senator Gordon. Mr. President, distinguished colleagues, bigo na naman po si Carlos Miguel Francisco, ang mukha ng endo at kontraktualisasyon. Magpapatuloy po ang kwento niya na tuwing matatapos ang kanyang kontrata, jobless at wala siyang kasiguruhan kung kailan siya ulit makakakuha ng trabaho. Isa lang po siya sa halos 2 milyong manggagawang nangangarap na mawakasan na ang endo. At simula pa lamang ng pagbukas ng 17th Congress, inasahan na po natin, Ginoong Pangulo, na maraming haharang sa panukalang ito. Subalit, hindi po tayo natinag. Lalo na po at maraming manggagawa ang umaasa rito na tutuldok sa endo. Ngayon, pansamantalang naantala ito. Ang issue, Ginoong Pangulo, ng endo at pang-aabuso sa kontraktualisasyon ay parang butas na tubo. Tuloy-tuloy nasisirit ang tubig hanggat hindi ito tuluyang nakukumpuni ang leak o tagas nito. Kaya muli po nating isinumiti kanina, Ginoong Pangulo, ang Senate Bill number 806 para masawata ang pagsasamantala at hindi makataong pagtrato sa ating mga manggagawa. Patuloy po nating isusulong ang panukalang batas na ito hanggang hindi po nawawakasan ang pang-aabuso sa kontraktualisasyon at hindi ganap na tinatamasa ng mga manggagawang Pilipino ang tunay na seguridad sa trabaho. Tuloy po ang laban sa endo. Muli, maraming salamat, Ginoong Pangulo, at sa lahat po ng kasama natin na nagsulong ng panukalang batas na ito. May God bless us all.
The Minority Leader is recognized.
Thank you, Mr. President, for the recognition. Will the gentleman sponsor of the Security of Tenure Bill, the gentleman from Bulacan, yield the floor to a few clarificatory questions?
Most definitely, distinguished colleague, especially from our distinguished colleague from Iloilo, our Minority Floor Leader, Senator Frank Drilon.
The gentleman, Mr. President, presented a copy of the certification of Malacanang dated September 21, 2018, certifying to the necessity and immediate enactment of Senate Bill 1826. And the title of the bill is clearly specified. Mr. President, from what I recall, the certification was issued when the committee report contained Senate Bill 1826. This is a committee bill at this point, not only a bill of the good gentleman from Bulacan. Is that a correct recollection, sir?
The distinguished minority floor leader is correct, Mr. President. This is a committee report, and this is not just the bill of this representation, but the consensus of the members of the Committee on Labor and Human Resources Development.
When the bill was passed, it basically followed the principles outlined in Senate Bill 1826, which was certified as urgent. Is that a correct statement, Mr. President?
Yes, Mr. President, that is correct.
And therefore, the Senate passed the bill as certified by Malacanang, at least in substance. Is that
Yes.
correct, sir?
Yes, Mr. President, exactly correct.
So, Mr. President, why was it vetoed?
Your question is as good as mine, and that's the same reason why I rise today, Mr. President. And in trying to pinpoint exactly what the veto message is all about, no less than the Senate President pro tempore made mention that there was no particular provision being pointed out by Malacanang as to why this particular measure was vetoed, Mr. President.
Oh, do we have a copy of the veto message?
Yes, Mr. President, I have it here with me.
And does it specify the reasons for the President's disagreement with the version that was certified as urgent and an administration measure?
It's in general form, Mr. President, as mentioned a while ago. For example, the definition of labor-only contracting, which this representation already stated that it is the same definition that was certified by the President in September 21, 2018.
Now that you have mentioned again the certification, as the gentleman is aware, under Section 26, Article 6 of the Constitution, the certification would dispense with the 3-day rule, meaning that with the certification of the President, the constitutional requirement that the bill must be presented in printed form 3 days before third reading is dispensed with. Is that a correct statement, Mr. President?
Yes, we submit, Mr. President.
And the certification under the Constitution is based only on the following standard, that the necessity of immediate enactment is, quote, to meet a public calamity or emergency. Does the gentleman recall that statement in the Constitution, Mr. President?
Yes, Mr. President, we submit.
What is then the public calamity or emergency that was the basis of this certification?
I would submit to the wisdom of the minority floor leader. I don't see any basic calamity whatsoever, as it was certified, Mr. President, by Malacanang.
Yes. We do not see any public calamity.
Yes, we agree, Mr. President.
No.
And other than that, we have heard several times the President himself talking about the importance of this particular measure, that he needed to pass this measure as part of his campaign promise. We heard last year's SONA that this is indeed an important measure that we should pass, Mr. President. So as a matter of courtesy and with the certification of the President, we comply, Mr. President, with the request of Malacanang.
In other words, if somebody will question the constitutionality of this certification, that's a matter for them to bring to the courts if indeed they find it unconstitutional. But having said that, Mr. President, that is the technical aspect of a certification, the constitutional aspect of the certification. The policy issue is when the President certifies a bill as found in the committee report, the President agrees with the contents of the committee report because this is certified then as an urgent administration measure. Is that a correct statement, Mr. President?
I cannot agree more with the statements made by our minority floor leader.
So if you cannot agree more, can you tell us why the President vetoed the bill?
It's the same question that I have been profoundly asking, Mr. President. In fact, we filed the same committee report this afternoon, Senate Bill number 806, and to elicit the reasons from the officials of Malacanang as to why they opted or they influenced the President to veto the same measure, Mr. President.
Is that the basis for the statement of the gentleman in his privileged speech that raising a rhetorical question, is the certification meaningless?
That's exactly the point I'm trying to raise, Mr. President, because if it is meaningless, then we were misled for 3 years. I would remember, and let me put on record, the very first hearing of this particular measure is concerned, no less than the minority floor leader attended the Committee on Labor hearing, Mr. President.
Well, I think it's a little too much to say that we were misled. We assume good faith. Hindi naman siguro intensyon na linlangin ang Senado dito po sa pangyayari ito. Ngunit, sinabi po ng ating kagalang-galang na kapatid na galing sa Bulacan na mayroon po siyang isinampang bagong Senate Bill 806. Mr. President, how different is this from Senate Bill number 1826, which was vetoed?
This is the same committee report that was certified by the President as urgent and priority, Mr. President.
So, chances are when we pass this bill, Senate Bill number 806, it will again be vetoed.
Well, Mr. President, hope springs eternal, and perhaps we'll be able to convince some of the cabinet official who were against the particular measure. But let me point out, Mr. President, that the Department of Labor and Employment, the Department of Trade and Industry overwhelmingly supported the measure. Another thing perhaps, Mr. President, to console us and to give us more hope that this time around it will be given right attention, Mr. President, is that we have here with us our colleague Senator Bongo, who would probably be able to explain properly the measures that we are deliberating and tackling here in the Senate.
If Senate Bill 806 is again vetoed, would the gentleman agree with the statement, sobra na yan?
I will cross the bridge, Mr. President, once we arrive at it, Mr. President.
And if again the Senate Bill 806 is vetoed, would the gentleman from Bulacan lead the chamber in overriding the veto?
If the distinguished minority floor leader would support me, perhaps I will consider, Mr. President.
We are just in the minority. There are just 3 of us, but we can assure the gentleman that we will support him if indeed he finds it totally unjust and meaningless. If the bill is again vetoed. According to Senator Gordon, kawawa naman, tinuturo si Senator Villanueva po.
Are you not going to suggest that he moves to override?
I'm sorry?
Are you not going to suggest to Senator Villanueva to move to override?
Yes, in this particular measure, if he is prepared, we are already ready. We're ready to support him. And if he does not get the support, maybe Senator Villanueva can move over to the minority.
I see no reaction, so...
So he's not willing to lead, and he's
No,
not
no.
willing to move to the minority,
he's not,
Mr.
well,
President.
he's not willing to move.
I have to confess that the Senate President advised this representation to refile the measure, Mr. President. And that's one of the major reasons why we...
I agree with the Senate President. Let us give ourselves another chance to try to convince the President that this is the right measure.
Convince the President or convince a cabinet official?
It's just one cabinet official that...
Oh, Mr. President, the cabinet official is an elected official of the government. We are the elected representatives, and the President represents the mandate of the people, and it is the President who finally decides on this measure, not the cabinet official. Mr. President, going to another topic,
I'm sorry.
is this the first time that this happened, Mr. President?
If I'm not mistaken, as mentioned by the Majority Floor Leader during the Committee on Rules hearing this afternoon, this is the second time. The first time was that of the Coco Levy measure, Mr. President.
Is your question, Your Honor, is your question related only to the 17th Congress?
Two?
The 17th Congress only?
Yes, only to the 17th Congress. So, just on the 17th Congress, we would like to know for the record, if this is the first time where a certified measure, the contents of which we patterned after the certified measure, contents of the certified measure was vetoed. In other words, there appears to be no consistency. Is this the first time that this happened?
Mr. President,
Zero the leader.
with the permission of the two
Yes,
gentlemen, this is not the first time, this is the second time. The first one was authored by the dear lady senator celebrating her birthday today on the Coco Levy Fund, which was also certified. Yes, and she's also refining the measure, and this is the second time. But this is unprecedented, Mr. President.
Second time,
Yes, Mr. President.
with a certification.
Yes, Mr. President.
Without a certification, there were others.
Yes, we have
My colleague,
the number one,
Mr. President, is
the number
shouting
one
many.
in terms of veto, Mr. President, the number one author is Senator Gordon. With
What
the
did-
three
right.
measures.
How many bills authored by Senator Gordon were vetoed, Mr. President?
Three, I believe, Mr. President.
How many? How many?
Three measures.
Louder.
Three measures.
Three measures authored by Senator Gordon
I
were
believe so.
vetoed.
And we have also for Senator Villar, we have two measures.
Two measures. And
Yes, Mr. President.
is that about it?
And then we have Senator Joel Vidal, who have one measure.
Okay. So
Mr.
one,
President.
And Senator Risa Contiveros also one.
one measure. So
As a point of information, Mr. President, one of the bills vetoed,
With the permission of the gentleman and Senator Villanueva, you originally have the floor. You're sitting down. You're not,
I'm being courteous to the gentleman from Zambales, Mr. President.
All
He
right.
is the Manny Pacquiao of all vetoed bills, Mr. President.
all right, Senator Gordon is recognized.
I just wanted to clarify, Mr. President, because I found it really abhorrent that a certified bill would be vetoed. And at the same time, a bill or bills that have been approved by both houses of Congress after long deliberation, hard work, research. You know, I don't think it's the fault of the President. I think it's the people around the President that keep trying to give him what I call the last touch treatment. Meaning to say, we invite all of these cabinet members here, and when they come, they should say, we don't want it, or at least have a LEDAC meeting, or at the very least, say, we want to make adjustments on this bill, instead of vetoing it, because it costs a lot of taxpayers' money, it costs a lot of hard work, our staff are overwrought, and all of a sudden, it will be vetoed. Especially, for example, Mr. President, the OSG bill. I did not file that bill. They lobbied. I got the bill, and because it went to the Department of Justice, out of courtesy to the branch of the President, we worked very hard. Senator Dillon and I worked very hard. We had extended debates here to make the bill better. But when it didn't come out the way they wanted it, apparently they decided to veto it. To me, that is really ridiculous because it's a bill that would have benefited many of the Solicitor Generals. And it really is a sad state of affairs because the Senate is a co-equal branch, along with Congress, of course. But it is important that we let the Office of the President know that they cannot treat us in this manner. Not that we are entitled to it, although God knows we are because we are a respected branch of the government, but really to save the government's time, save taxpayers' money, and make sure that we are able to succeed in crafting good legislation. Certainly, it really renders our enthusiasm, inutile practically because we want to make sure that kaya natin gawin lahat yung mga batas na ginagawa, pinaghahandaan. Ilan po, Mr. President. I will now return the floor to my colleague, the pastor from Bulacan.
The floor is now with Senator Drilon.
Yes, Mr.
Because
President.
Senator Villanueva sat down.
Mr. President, yes, I agree with Senator Gordon that, in fact, a closer coordination would have prevented this situation from happening. As in measures that are not certified as urgent and administration measures, I think our system of check and balance would empower really the President to veto. There is nothing that we can say about that. He disagrees with the policy that the Congress proposes, and it is within the right of the President to veto. What we are just raising in issue is where the President has agreed on a certain policy as evidenced by the certification issued, and afterwards veto that policy which we thought at the start he agreed with. Now, there was even an instance here, mention was made of the Coco Levy bill. Mr. President, I have been 21 years in the Congress, and that was the first time I witnessed an episode wherein after the Senate and the House ratified the Bicameral Conference Committee report and sent the enrolled copy to Malacanang, Malacanang said, we are not in agreement with 1, 2, 3, 4, 5. And therefore returned to us the measure. Unprecedented, both chambers reconvened the Bicameral Conference Committee.
Humbled themselves.
Abolished.
Humbled themselves.
Humbled itself. Abolished reconvened the Bicameral Conference Committee and set us and once more sent the measure to the Bicameral Conference Committee, and what we thought corrected the objectionable portion. And Senator Villar worked hard on this. She did, in her honest effort, tried to recast the bill in order to meet the objections which we recognized. After the bill was passed for the second time and sent to Malacanang, nabito uli. This one really, beats every rule that we know. So here, I think, Mr. President, is a failure of coordination. We are not questioning the right of the President to veto. We are only raising an issue, vetoing a measure which was certified as urgent as an administration, and vetoing a bill after it was returned to us, and we corrected it. This, to me, I'm standing here expressing, I hope, the sentiments of the institution, not only of the opposition, that these things should not happen, which means maybe that we should have a better PLLO coordinator.
What's that? What's that? What's that, Your Honor? What's that? What's
Who?
What's PLLO?
I do not know who is the PLLO coordinator, Mr. President. We do not know because we have very little interaction. But levity aside, we are guessing. We exercise our independent judgment. But the reality in this world And in the reality of our setup, the government, the president approves or vetoes a measure. That is our system of check and balance. But having said that, however, it does not remove the fact that we are so frustrated when, after working on a measure, especially after the president has certified the same to be an administration measure, it gets vetoed. Yes, the majority leader who has told me to tirahin mo.
No, in this particular case, I'll do it myself, Your Honor. Because, to be very honest, I concur fully with the distinguished minority floor leader. We have no questions about the power of the president to veto a bill, Mr. President. That is his, ika nga, kapangyarihan po niya yan eh. He can do that. That's his, he's allowed by the Constitution to veto measures. What boggles the mind, and I mentioned it over the weekend out of sheer frustration in an interview, is that these are certified measures. And this particular one is signed by our dear President, Mr. President. And that is my point. My point is on the certification of these measures. If it is certified, we let it slide. Actually, I was very patient in the first certification which was vetoed, which is the Coco Levy bill. Tahimik lang muna kami. But on this second particular measure, Mr. President, I think we should be clarified by Malacanang, or we should seek clarification from Malacanang, what is the purpose of this certification? Case in point, tomorrow we are supposed to meet with Secretary Dominguez. I think he's supposed to brief. Is that pushing through?
I think it was moved to August 5, Monday.
August 5. Therefore, when we meet with him on his priority measure, which is the Trabaho Bill, that Trabaho Bill, Mr. President, although it will bring down the corporate income tax to a lower amount, it will remove incentives of several industries affecting hundreds of thousands of Filipinos. What if it is now certified once again? We take several months passing it, knowing Senator Recto, our dear minority floor leader, and the other members here who want to improve the measure, it will be bloody on the floor. And when we take that up, and then another lobby group will approach our dear president, another Chamber of Commerce, another group will approach the president to have it vetoed, and it is vetoed, well already certified. That is something I think that we should properly get coordination with Malacanang, and that this may not happen again in the future. In fairness to Senator Bongo, I spoke to him today. We had a nice discussion outside, and he pointed to me that on August 5, in the mini LEDAC, he will point this out to the members of the cabinet. If you ask my simple and humble opinion, simple understanding and humble opinion of the matter, I believe the Department of Labor was pushing this. As a matter of fact, we received calls from Secretary Bello and some members who are sympathetic to the cause. Some members of cabinet sympathetic to the cause of this. Even Secretary Sal Panelo, who is the presidential spokesman, had talked to me and asked me what the status of the measure is because of his updates with media. And I said, Secretary, within the next 2 days, approve ito. So they knew for a fact. They were asking and coordinating with us. As a matter of fact, I will not mention who the secretary is. There was a secretary being interviewed in TV, and he said, tapos na ang House, kami, pinacertify na namin, inuupuan ng Senado. It's there in the Senate being sat on. I take that as an offense because now we double time, we worked hard. I appeal to the minority floor leader to assist us on this because this is what the President and Malacanang wanted to happen. So, Mr. President, yun lang. Ang punto ko lang dito bilang majority floor leader, sana hindi po tayo mapapaya muli na isang certified measure ay mabivito lamang. Yun lang po. Regardless of what issue, what the topic may be. Because being certified, it is a policy. It's a policy statement of the palace telling us that we want this measure. As a matter of fact, let's just wait for them to write the new security of tenure measure, just to be sure. They used to do that in previous Congresses, wherein Malacanang-sponsored measures were actually given by them for us to further study, amend, and to file. Maybe that could be one suggestion we can put forward in our mini LEDAC or in the LEDAC itself. Because it is very tedious and tiring, Mr. President, and frustrating. As you were distraught, I was distraught too. We worked hard on this. Ito na po yung last 2 minutes natin. Nagpalakpakan po tayo lahat dito when we passed this. It was like a big thorn pulled out of our backs. 21 years we've been fighting for this measure. And Senator Joel is correct. I was in SM the other day. I was in our home ng SM. I was buying a chair for my kids. And the guy one of the salesmen came up to me and says, "Paano yan, sir? Hindi na po matutuloy yung security of tenure." Sabi ko, wala na kami magagawa, na veto na. That's the stark reality of it. These people are affected. So, I'm making an appeal, and I'm glad that he refiled the measure, but I hope it doesn't go back again to being vetoed. Kasi kawawa naman yung mga kababayan natin. Yung mayaman na po yan eh. Sobrang yaman na talaga nila, Mr. President. So, again, as your majority floor leader, a majority floor leader of the Senate and chairman of the House Committee on Rules, we just want to be clarified on the issue of certification. Because like I said, the trabaho bill, whether it be certified, mamaya ma-veto, huwag na natin pag-usapan. Kung ganun lamang. Maybe siguro we'll seek clarification straight from the President and see if he will approve it or not before we tackle the measure. Kasi sayang po yung hirap natin dito. Well-meaning, hardworking members of the legislature. It's quite disheartening. I just wanted to put my 2 cents worth, Mr. President.
Maybe, Mr. President, if I may suggest, we express our sentiment that presidential certifications should adhere strictly to the constitutional mandate, and that is to address emergency or public calamity. And unless these standards are present, to refrain from issuing a certification so that it will not be embarrassing if after we heed the certification and pass the measure, it will be vetoed. At least if it is not certified and the President vetoes the measure, it is simply in exercise of his power under the Constitution without entangling himself with an inconsistent position where after certifying a measure as an administration measure and therefore must be passed urgently, he vetoes the measure. That is our suggestion, to send a message to Malacanang. Exercise the right to certify strictly on the basis of the constitutional mandate. Thank you very much, Mr. President. And with that, we no longer have any question on the sponsor, on the gentleman from Bulacan.
Thank you very much, distinguished colleague from Iloilo. Let me close, Mr. President, by saying that
Yes,
I rise here today not only for myself or the Committee of Labor, but also for the institution, but more importantly for the more than 2 million workers na naaabuso po sa evils of contractualization. Let me again thank my distinguished colleagues who helped me out in the 17th Congress, and we hope and pray that the same support ang makukuha po natin this coming 18th Congress. Again, for the record, we did our part, Mr. President. We are more than willing to walk the extra mile to help our countrymen and people. And we are hoping and praying that this time around we'll be able to see the light at the end of the tunnel by passing this anti-endo bill. Maraming salamat po at pagpalain tayong lahat ng ating Panginoong Diyos.
Senator Gordon.
Mr. President, may I, if I may, advise my colleague here that it might be better now, for an example, so that the public will be more aware of the injustice of the situation, if he starts calling individual companies who are practicing endo and put it under the light of scrutiny. Because right now, public scrutiny, because right now, natatalo tayo ng hidden faces in the cabinet or anywhere else by citing the specter that it will drive away business. I am of the opinion that that may be so, Mr. President. That may be right, that there may be basis for that, that business will be afraid to go into business because it becomes less predicted, less capable of being predicted. But on the other hand, if the gentleman from Bulacan would focus on certain companies that are in fact doing this malpractice, I think it will go a long way in letting the public understand, because half the problem is letting the public understand how vituperative and how pervasive this practice is. That is all, Mr. President. Thank you.
All right, thank you.
We'll definitely take note of that, Mr. President. We'll submit to the wisdom of the distinguished gentleman from Zambales. Thank you.
Okay. Senator, the Majority Leader.
Mr. President, we refer the privileged speech of the good gentleman to the Committee on Labor, Mr. President.
Any objection? There being none, motion is approved. Referred to the Committee on Labor.
Thank you. Just some housekeeping matters, Mr. President. The Senate Resolution number 6, with the permission of the body, this is a resolution to conduct inquiry in native legislation on national poverty situation, include comprehensive review and assessment on existing poverty data. Be transferred, or the referral be transferred from the Committee on Social Justice to the Committee on Economic Affairs. I so move, Mr. President.
Any objection? Hearing none, so moved.
Thank you, Mr. President. We have several committees, Mr. President, who would like to elect their members. If we may prioritize this, because so that they can conduct their hearings, if it's all right with the permission of the body. For the Committee on Civil Service, Government Reorganization, and Professional Regulation, the chairperson of this committee, Senator Bong Revilla. I move to elect Senators Joel Villanueva, Senator Bongo, Senator Bato de la Rosa, Senator Francis Tolentino, Senator Pia Cayetano for the majority, and for the minority, Senator Risa Ontiveros. I so move, Mr. President.
Any objection? There being none, enumerated names are elected.
Mr. President, for the Committee on Constitutional Amendments and Revision of Codes, this is chaired by Senator Kiko Pangilinan. For the part of the majority, Vice Chairperson Lacson, Senator Sangara, Senators Grace Poe, Senator Manny Pacquiao, Senator Richard Gordon, Senator Francis Tolentino, Senator Christopher Bongo, Senator Cynthia Villar, and Senator Nancy Binay. And on the part of the minority, Senator Ontiveros. I so move.
Any objection? Hearing none, so elected.
On the Committee on Cooperatives, Mr. President, where I'm the chairperson, I move to elect Senators Risa Ontiveros, Senator Sherwin Gatchalian, Senator Cynthia Villar, Senator Christopher Bongo, Senator Francis Tolentino, Senator Lito Lapid, Senator Richard Gordon, and for the part of the minority, Senator Kiko Pangilinan. I so move, Mr. President.
Any objection? Hearing none, so elected.
For the part of the on the Committee on Economic Affairs, I move that we elect, this is the chairperson here, Mr. President, is Senator Amy Marcos. On the part of the majority, we move to elect Senator Sonny Angara, Senator Pia Cayetano, Senator Sherwin Gatchalian, Senator Lito Lapid, Senator Bong Revilla Jr., and Senator Francis Tolentino, and for the on the part of the minority, Senator Kiko Pangilinan and Senator Risa Ontiveros. I so move.
Any objection? Hearing none, so elected.
Mr. President, this is for the Committee on Electoral Reforms and People's Participation, the chairperson, Senator Amy Marcos. I move to elect Senator Ping Lacson as Vice Chair, and members Senator Maria Lourdes Nancy Binay, Senator Ronald De La Rosa, Senator Christopher Bongo, Senator Aquilino Pimentel III, Senator Ramon Bong Revilla, Senator Francis Tolentino, Senator Cynthia Villar, and on the part of the minority, Senator Kiko Pangilinan and Senator Risa Ontiveros.
Any objection? Hearing none, so elected.
Mr. President, on the Committee on Environment and Natural Resources, this is chaired by no other than Senator Cynthia Villar, Senators Francis Tolentino and Senator Pia Cayetano as Vice Chairs, and Senators Lourdes Nancy Binay, Senator Bato de la Rosa, Senator Amy Marcos, Senator Manny Pacquiao, Senator Joel Villanueva, Senator Lito Lapid, Senator Richard Gordon, Senator Bongo, Senator Sherwin Gatchalian, and for the minority, Senator Kiko Pangilinan, Senator Risa Ontiveros, and Senator Laila De Lima as members. I so move.
Any objection? Hearing none, so elected.
The Committee on Finance will just take up tomorrow. I believe we're going to sponsor the amendments to our rules, so we'll take this up tomorrow, Mr. President, with the permission of the chairperson of the Committee on Finance. On the Committee on Games and Amusements, this is chaired by Senator Lito Lapid. We have Senator Ping Lacson, Senator Christopher Bongo, Senator Manuel Pacquiao, Senator Bong Revilla Jr., Senator Francis Tolentino, and Senator Amy Marcos. For the minority, Senator Laila De Lima and Senator Kiko Pangilinan. I so move, Mr. President.
Any objection? Hearing none, so elected.
Mr. President, on the Committee on Health and Demography, for the majority, the chairs, it's being chaired, Mr. President, by the distinguished senator from Davao, Senator Bongo. Vice Chairpersons, Senator Pia Cayetano, Senator Lourdes Nancy Binay, and for the majority, Senators Ronald De La Rosa, Senator Francis Tolentino, Senator Amy Marcos, Senator Richard Gordon, Senator Panfilo Lacson, Senator Aquilino Pimentel, and for the minority, Senator Risa Ontiveros, and Senator Kiko Pangilinan. So move.
Any objection? Hearing none, so elected.
Mr. President, on the Committee on Labor, Employment, and Human Resource Development, this is chaired by Senator Joel Villanueva. We move to elect the chairperson, the members, as vice chairperson, Senator Nancy Binay, Senator Bongo, Senator Sherwin Gatchalian, Senator Sani Angara, Senator Bong Revilla Jr., Senator Francis Tolentino, Senator Manny Pacquiao, Senator Ronald De La Rosa, Senator Panfilo Lacson, and Senator Coco Pimentel, and for the minority, Senator Hontiveros and Senator Pangilinan. I so move.
Any objection? Hearing none, so elected.
For the Committee on Public Works, where the chairperson is Senator Manny Pacquiao, I move to elect for Vice Chairperson, Senator Bong Revilla Jr., Senator Sani Angara, and members Senator Lacson, Senator Lito Lapid, Senator Bato de la Rosa, Senator Francis Tolentino, Senator Joel Villanueva, Senator Grace Poe, Senator Christopher Bongo, Senator Richard Gordon, and for the minority, Senator Laila De Lima, and Senator Francis Pangilinan.
Hearing no objection, so elected.
Mr. President, this is for the Committee on Social Justice, Welfare, and Rural Development. The chair is Senator Laila De Lima. For the majority, Vice Chairpersons, Senator Nancy Binay and Senator Amy Marcos, and members Senator Joel Villanueva, Senator Pia Cayetano, Senator Bato de la Rosa, and Senator Ramon Bong Revilla. I so move.
Any objection? Hearing none, so elected.
Mr. President, this is the Committee on Sports. For the majority, the chair is Senator, we already elected Senator Christopher Bongo on this committee, and we move to elect the Vice Chairperson, Senator Manny Pacquiao, and members Senator Pia Cayetano, Senator Ronald De La Rosa, Senator Francis Tolentino, Senator Joel Villanueva, Senator Ramon Bong Revilla Jr., for the minority, Senator Laila De Lima, and Senator Risa Ontiveros.
Hearing no objection, so elected.
On the Committee on Youth, the chairperson is Senator Sani Angara. I move to elect the rest of the committee members as vice chair, Senator Amy Marcos, members Senator Nancy Binay, Senator Laila De Lima, Senator Christopher Bongo, Senator Manny Pacquiao, and Senator Joel Villanueva. I so move.
Hearing no objection, so elected.
Trade and Commerce, tapos na? Wala. Tapos na? Ah, hindi pa? Okay. Trade and Commerce, we have not read yet, Mr. President, right? So I move, Mr. President, to elect the members of the Committee on Trade, Commerce, and Entrepreneurship. This is headed by Senator Coco Pimentel, the Vice Chairperson, Senator Sherwin Gatchalian, and Senator Grace Poe, together with Senator Gordon, Senator Villar, Senator Sani Angara, Senator Nancy Binay, and for the minority, Senator Kiko Pangilinan, and Senator Laila De Lima. I so move.
Hearing no objection, so elected.
And the Committee on Foreign Relations, who will be tackling the first privilege speech of this 18th Congress. The chair is Senator Coco Pimentel, and Vice Chairperson, Senator Richard Gordon, Senator Francis Tolentino, Senator Bato de la Rosa, and Senator Manny Pacquiao, and members Senator Christopher Bongo, Senator Ping Lacson, Senator Lito Lapid, Senator Joel Villanueva, Senator Maria Lourdes Nancy Binay, Senator Bong Revilla Jr., Senator Grace Poe, and for the minority, Senator Risa Ontiveros, Senator Kiko Pangilinan, and Senator Laila De Lima. I so move.
Hearing no objection, so elected.
Okay lang, resolution lang sa iglesia. Mr. President, with the permission of the body, I move that we consider proposed Senate Resolution number, PS Resolution number 37. I so move, Mr. President.
Any objection? Hearing none, consideration is in order.
May we request the Secretary to read the title of the measure?
Secretary will read the title of the measure without prejudice to inserting into the records text of the said resolution.
Resolution commemorating the 105th founding anniversary of the Iglesia ni Cristo INC, commending the leadership of Ka Eduardo V. Manalo and recognizing its contribution to the Filipino and the world.
Mr. President, the status of the measures were in a period of sponsorship. May I be recognized to sponsor the measure?
Senators, the majority leader is recognized.
Thank you, Mr. President. Mr. President, let me take this moment to recognize an outstanding milestone for the Iglesia ni Cristo as they celebrate their 105th anniversary. For 105 years now, and with around 3 million members here and abroad, the Iglesia ni Cristo has been a stalwart religious umbrella that has been influential in shaping the country's moral fiber and spiritual integrity. Aside from sharing the teachings of Christ, the INC has spearheaded large-scale social work by extending assistance to those in need through missions such as Lingap sa Mamamayan or Aid for Humanity program, an integrated social civic service that offers medical and dental service as well as blood donation drives and provides reinforcement in times of calamity and disaster. With their spiritual, material, and cultural contributions, the Iglesia ni Cristo's nation-building influence really cannot be denied. We would be a different nation if it not had been for the enduring presence of the INC for the past 105 years. So, Mr. President, let me congratulate the INC and wish them more success and several programs and projects for the good of our country and their institution. With that, Mr. President, I ask the Senate to approve this measure. Mr. President?
Mr. President,
Yes.
if I may, with the indulgence of the Majority Floor Leader, may I be, with the permission of the Majority Floor Leader, that I be included as one of the co-authors, Mr. President.
Thank you. Thank you, Mr. President. That comes from an equally large and distinguished group, leader of a distinguished group, such as the Jesus is Lord Church of God. Mr. President, may I move that we make all members of the 18th Congress as co-authors with the permission of the body, Mr. President.
All right, so recorded.
No other member wishes to interpolate and propose amendments. I move to adopt Senate Resolution number 37, subject to stat.
Any objection? Hearing none, PS Resolution 37 is hereby adopted, subject to stat.
Thank you, Mr. President. Mr. President, we have a request by the Honorable Senator Sancho Villar to elect the members of the minority in her Committee on Agrarian Reform. Hindi pa ba sila na-elect? The two members in the minority. I move to elect the part of the minority, Senators Pangilinan and Senator Hontiveros Risa. I so move.
Hearing no objection, so elected.
And the chairperson of the Committee on Energy, Senator Win Gatchalian, would like to nominate Senator Francis Tolentino as member in lieu of Senator Joel Villanueva, who was previously nominated as member of. We have to ask permission. Did you agree to this? No? Unfortunately, Senator Joel Villanueva is also disheartened by leaving the committee on Senator Gatchalian. So it's a double whammy for Senator Joel. No, but he's in agreement with the proposal of Senator Gatchalian to exchange his seat for Senator Francis Tolentino. I so move, Mr. President.
Any objection? Hearing none, motion approved.
We have may I ask for 1 minute suspension?
No, the Senate suspended for 1 Senate minute. Session resumed.
Thank you, Mr. President. Mr. President, I have good news for our colleagues. We'll just tackle the reference of business tomorrow. It's a very lengthy number of measures. It will take, I'm sure, over 45 minutes to finish, so we'll take it up first thing in the morning, in the afternoon. But, Mr. President, may I just appeal to the colleagues that are still here, after we adjourn, to just step into the lounge for a few minutes to discuss our calendar. We were given the calendar already by the House of Representatives, their requested calendar, so that we can fine-tune our two calendars, Mr. President.
You should bring your hatchet man there in the Senator's lounge.
Yes, he's so requested to attend, Mr. President. Mr. President, with that, I move to adjourn session until 3 o'clock in the afternoon of Tuesday, July 30, 2019.
All right, any objection? There being none, the session is adjourned until 3 o'clock in the afternoon of Tuesday, July 30, 2019.